May I please, Lordship?
Yes.
Lordship, I beg to mention item number 1 and 2, Lordship. Lordship, here the senior counsel, PJ Sekia. Lordship, his matter could not
Oh,
be
yes,
listed
yes,
before you.
yes, yes.
So this both matter to be listed on 4th of December.
4th of December. List this matter before any other
1 and 2.
bench without one of us. Mo naam to likhi diba.
And Lordship, item number 3,
Hmm.
this matter may be listed after 3 weeks, Lordship.
Item number 1 and 2 on 4th December?
On 4th December and item 3 after 3 weeks.
After 3 weeks.
Yes.
After 3 weeks.
Lordship.
You have taken consent from the other side?
Yes, I have informed.
Naam to likhi diba de yaar.
3.
3 or 2? Or 3?
1, 2, 3.
1 and 2 is
for-
on the other side we have for the petitioner and appellant we have PJ Sekia. 1 and 2.
Yes.
So that I cannot take up.
Yes.
So that I am fixing.
Even 3 PJs again.
Even
Also-
3 also.
Also
I
3,
cannot
yes.
take up.
That is well, Lordship. 1 and 2 to be listed on 4th.
All right.
And item 3 to be after 3 weeks. Deeply obliged.
Item number 4.
In item 4,
Mhm.
last time there was a undertaking,
Mm.
there was a undertaking by the department saying that the road construction work would be completed by the 31st of March 2025,
Mm.
subject to availability of funds, my lord.
Mm.
My lord, funds were not available, my lord. In fact, 22 crores were sought for,
Mm.
and only 12 crores were sanctioned. 12.9 crores were sanctioned. So now the remaining fund
Mm.
will be sanctioned, my lord. Therefore, my lord, the work will be starting soon, my lord.
So leave a date open then.
Yes, my lord.
When
Can it-
you get the fund sanctioned, then we'll fix it up to then. But
Can it be fixed on in the second week of
so he is assuring that funds will be sanctioned, entire funds will be sanctioned, so we'll fix a date.
Your Lordship, actually, this matter is pending for long, and they have assured 3 times now it's been after filing this matter. So last time they have assured that they will finish by 31st of March 2025. So till now they haven't filed any status that what is the condition of the road. So how we can,
You can,
sorry,
you can submit,
there was traffic.
you can submit comfortably also.
So how we can trust them that even in affidavit, they have said that they will finish by 31st of March. So at what condition we will
today?
trust them?
We are producing the status report today. We will be furnishing him. Yes, my lord.
So you're asking for
Some more time, my lord. My lord,
how many weeks?
can this be in the second week of January then, my lord?
That will be too long.
That will too long.
Then December, can it be on 19th of December?
Just before holidays.
Yes, my lord.
Then
Because now, my lord,
automatically
as per
it's
this
slip of the
status
second
report,
week of January.
they are going to start again, my lord. This is the working season. They are going to start.
Okay,
so-
yes, winter season, I think.
Yes, my lord.
Your Lordship, it's difficult for me. I can just submit that.
Some days
We-
just before the holiday vacation, some days, a few more days before the vacation, when the vacation starts. When will the vacation start?
24,
25th.
From 25th. Okay, 19 is fine.
19.
You'll have to, everybody will have to refresh my memory. I've come after more than 1.5 years.
Yes.
I have forgotten your names.
My lord, I'm N. Ratan,
And Ratan and
additional AG.
S. Somo,
S.
Sonam Somo.
S. Somo. Learned Counsel Miss S. Somo is present for the petitioner. And Learned Counsel Mr. N. Ratan, Government Advocate,
Additional AG.
additional Learned Double AG, Mr. N. Ratan is present and has submitted that, submitted and has prayed for time to complete the remaining part of the payment,
Work,
to complete the remaining part of the work.
madam.
As an assurance has been given that they will receive their entire funds by then, all right?
Yes, madam.
List this matter on 19 December.
Yes.
The Learned Counsel for the Heri Likhit has raised objection as and has submitted that several adjournments have been taken after assurances of completion of work has been given by their this will be the respondents.
Lordship, I appear
Okay,
for
sir.
respondent number 13 and 14. Lordship may record that if Lordship.
Hmm.
Is-
13 and 14? Yes.
Lord. That is the contractor. I appear for them. The instructions are the same as learned AGS place, Lordship. My name is D. Dekar.
Learned Counsel Mr. here D. Decker is present for respondent number 13 and 14.
Yes, Lordship. Highly obliged, Your Lordship.
Item number 5.
May Lordship.
Just a moment. Also switch it off. It's okay. Auto switch it off or not? This is on and off. Just press, no? Once I'll press, then it will be off, and once it will be off, okay.
May Lordship. Lordship, in the last occasion, Lordship, respondent counsel has informed before this honorable court that one special leave to appeal has been in connected to this matter has been filed before the Supreme Court.
Hmm.
And he is supposed to produce the order of the Supreme Court today, Lordship, before this honorable court.
Who is present?
Lordship, senior counsel is appearing through DC, Your Honor. Lordship,
Yes, yes.
for respondents.
Hmm. Yes.
Our SLP is being processed. Unfortunately, there's many documents happen to be dim. We are getting them typed and getting them refiled. So in the process, it's likely to take some time. We are seeking more accommodation by your lordships. It
Then,
was filed
Lordship.
as early as on 13th October. It is being processed. After the defects are removed, then it will be refiled.
Then Lordship, let them file a counter affidavit, Lordship.
Yes,
Yes.
within 3 weeks, I'll file my counter affidavit.
Okay.
Wakalatnama has been filed this morning, Your Lordship.
Today morning.
Lordship.
D. Pangi?
D. Lona,
D. Lona. For
on
D.
behalf of
Pangi.
Mr. Deepak.
Learned Counsel Mr. D. Lona on behalf of Mr. D. Pangi is present for the petitioner. Learned Counsel Mr.
Naresh Kaushik, Senior Advocate.
Naresh, Learned Senior Advocate Mr. N. Kaushik is present for the respondents and has submitted for time to file counter affidavit and has also submitted. You have submitted something?
Yes,
Can you-
our SLP is being processed by the Honorable Supreme Court's registry for registration and listing in due course.
Okay. Has submitted that an SLP is being processed to be filed before the Supreme Court says before the registry of the Honorable Supreme Court. All right.
Yes, madam.
List this matter. When do you want?
3 weeks.
Let it be on 19th December, like earlier case.
19 December or 3 weeks?
Let's 19th December.
19 December. List this matter on 19 December.
All right.
Item number 6.
Lordship, this is FIAL challenging one state legislated act.
Mm.
Unlawful activities, Arunachal Pradesh Unlawful Activities Prevention Act, Lordship.
Yes.
Lordship, before I come into my submission, there are some constitutional provision especially when it comes to the concurrent list, Lordship. Preventive detention comes under the not in state list, Lordship. It comes under the concurrent list, Lordship. Lordship, may I go to the constitution, direct constitution?
Yes. Please help with the books.
Page 271, Lordship, in 7 schedule, Lordship, it is given.
271?
271, Lordship.
No. We'll check the 7th schedule then. This is, I'm taking another subscription, I think.
Same book.
This is universals.
Lordship, this is same book.
Same?
Yes, yes.
We do not have page 2.
Page number
We don't have page 271. You have page 271.
7 schedule, Lordship. This is 7 schedule, page number 271.
We'll go to 7th schedule, yes.
7 schedule exactly concurrent list, Lordship. List 3.
Yes.
Lordship, clearly, entry 3 is preventive detention. May, Lordship.
Entry 3,
Entry 3, Lordship.
7th schedule. List 3.
Yes. Preventive detention, Lordship. Preventive detention, clearly
What
this is
page?
reflected.
Yes.
Lordship, this is
Page 237.
Lordship, challenging act comes under the concurrent list, Lordship. This is very important. And then, Lordship, when it comes under the concurrent list, it is not absolute legislative power to the state list, Lordship. It is written in, again, Article Indian Constitution 554, Lordship. This is very important, Lordship. Lordship, 554. Oh, sorry, 254, Lordship. Extremely sorry. 254. 254, Lordship. Extremely sorry.
I'm looking at page 554.
Extremely sorry. Page number
There's
140,
no page 500.
142, Lordship.
No,
141.
This is not the same book.
Oh,
You
Lordship,
just give me the article. This is not the
Okay.
same book.
Five-
Pages are different.
254, Lordship. 254.
Okay.
Lordship, this has established that preventive detention comes under the concurrent list, list 3. Then 254 is inconsistency between law made by parliament and law made by the legislature of a state. Lordship. If any provision of law made by legislature of a state is repugnant to any provision of a law made by parliament, which parliament is competent to enact, or any provision of the existing law with respect to one of the matter enumerated in concurrent list, then subject to provision of the clause 2, the law made by parliament, whether passed before or after the law made by the legislature of the such state, or as the case may be, the existing law shall prevail, and law made by legislature of the state shall, to the extent of the repugnancy and void, Lordship, meaning thereby if,
Okay.
Lordship, and then, Lordship,
So you have this in the state,
Lordship, is that there is,
UAPA state? What is the entire act of the state?
yes, Lordship, unlawful activities, Lordship, I have annexed page number in my petition, Lordship. 39, the Arunachal Pradesh Unlawful Activities Prevention Act, Lordship.
Okay. All right.
Lordship. Now, Lordship, again coming to that, I have
Which is the, this will be section or section, which section of the act, local act?
Your Lordship, that I am coming to the section, Lordship,
Okay.
that from beginning, Lordship. This is phase number, Lordship, phase number 45. Here I have annexed the section 7, Lordship. May I see? Section 7 of the State Legislative Act.
Okay.
Section
You
7.
got the book, this book.
No.
We have one more of this,
Volume 12.
volume
12.
12. We have got one more of this, volume 12,
Yes.
page 45, section 7.
Section 7, Lordship. Lordship, may I read that
Yes.
I have challenged that 7(1)(a), the provision, sorry, 7, the state of the government of officer making an order under the subsection 1 of the section 3 has the reason to believe that person is in respect of the whom detention order has been made, has absconded or concealing himself so that the order cannot be executed. In that case, the provision of section 83, 82, 83, 84, and 85 of the Criminal Procedure 1973 shall be applied in respect of the said person, Lordship. Lordship, this is apply of the criminal procedure, whereas this section is purely for the, not for the preventive detention. This is for the punitive detention, Lordship. That whenever this section is codified in State Act and any act, whether it is made by Parliament, there is a provision that the written report to be made to the JMFC and Chief Judicial Magistrate, because this is purely exercised by the judiciary, Lordship.
Yes.
So this cannot be exercised by the executive magistrate. And then when it is exercised by the executive magistrate, Lordship, there is a basic structure in Kesavananda Bharti case in 1973. 3 organ has been divided. One, this executive magistrate and judiciary and legislature. Now, being this is part of the judiciary, this is completely encroached upon the field of the judiciary, Lordship. Then, Lordship,
When was this act enacted? Before
2014,
suppression of judiciary?
2014, Lordship.
That was before suppression?
Lordship,
After,
Lord-
after separation of judiciary?
after separation, like 2014, Lordship. Then, Lordship, and Lordship, even if there is a Parliament Act like National Security Act 1980, and then COPEPOSA, they are also invoke the 82, 83, 84, 85. In this condition, there is always condition that when this is codified, that writing of the report of the writing shall be made to the JMFC, Lordship, as if this order has been passed by the judiciary, because this section is for the judiciary, Lordship. And again, Lordship, that this will be followed by the Lordship, my judgment in after submission, Lordship.
Mm.
And again, Lordship, may I see the again section 9 of the State Legislative Act, Lordship, section 9. Article 22,
Okay,
Lordship, section 29, 9, Lordship.
yes, section 9. Yes,
Lordship, that section, the state government shall constitute one or more advisory board for the purpose. Every such board shall be consist of chairmen who shall be retired judges of the High Court, duly recommended, Lordship, retired judges. As per the article, this advisory board is indispensable condition of this act, Lordship. When advisory board is void and illegal, then entire act is illegal, Lordship, because this is indispensable factor, Lordship. Admit that, Lordship, Article 22, this is advisory board is given, Lordship. Because under the state law, retired judge is chairman, Lordship.
Yes. Under the state laws also.
State law, it is written. Then, as per the Constitution, Lordship, there should be provision for the sitting judge. Lordship, Article 22, 4, Lordship.
Hmm.
4A, Lordship. Article 42.
Yes, yes.
Lordship, may I see that?
Article
And
22, 4.
22,
5.
4. Yes, Lordship.
22, 4 only.
22, 4A, Lordship. Advisory consisting of the person who are and have been qualified to be appointed judge of the High Court, Lordship.
Mm. Yes.
They are comprised of the
22, 4A. Mm. Yes.
Yes, Lordship, as per the constitutional mandatory chairman and member. Among them, there must be one sitting judge, Lordship.
Yes.
Then, as per the State Legislative Act, there is no any provision for the sitting judge, Lordship. Because this Lordship, this condition comes in 1971, 72, 73, during emergency period of the Indira Gandhi, Lordship, when many were detained for the 19 months.
Mm.
That 44 amendment, there has been this adopted by the Parliament, Lordship.
So we won't go there.
Lordship.
We'll just remain here. We won't go
Exactly,
there.
Lordship. That this will be followed by after the submission, this Lordship, I will
Yes,
place the submission. Lordship, now the Constitution is mandated that judge who is and have been
Mm.
as a chairman, but as per the Afwafa retired judge, Lordship, this is severe and gross.
So there's a difference between the state act and the mandate of the constitution.
Yeah, exactly, Lordship. That as per the Constitution, sitting judge is there, and whereas as stated,
But it's not mentioned sitting judge of the High Court.
Lordship, judge of the High Court, in fact, Lordship, judge of the High Court, in fact,
Yes,
who is
yes.
sitting, Lordship.
Interpretation, yes.
Yes. And then, Lordship, regarding Lordship, period of the detention period, Lordship. Again, Article 22, Lordship, detention period. Lordship, detention period, this is a mandatory, not more than maximum detention period, 3 months, Lordship. And
Who is the, just a moment. Who is the petitioner here?
Lordship, this one, social activist Pai Gyade.
Social activists.
Yes, Lordship.
Yes.
And then Lordship,
What were you saying?
detention period, Lordship. Yes.
That your,
Lordship, may I see
just
again?
just a moment. How to switch it off? See, you're challenging a local act. So the other side, is the other side ready or because it, are you ready with it? You're
Yes.
challenging a local act.
Yes.
Okay, all right.
I'll address your lordship. Malad, this petition is not even maintainable.
Yes,
Your lordship will kindly see the prayer.
just a moment. Just a moment, let him,
Lordship,
let us hear him
Let's see.
for a moment.
Your lordship will come to the prayer in the writ petition. All the submissions are being made
Mm.
without pleadings. Where is? If your lordship will kindly come to
Prayer
page,
portion.
page 34, the prayer.
Mm.
And your lordship has rightly posed that question. Who are you?
Mm.
Who is he? A social activist coming and challenging a preventive detention act.
Yes, yes.
What business does he have? Your lordship will kindly come to page 34.
Yes.
Writ in the nature of certiorari shall not be issued to strike down or set aside of the Arunachal Pradesh Unlawful Activities Prevention Act 2014. The entire act is under challenge. And now, during the course of arguments, one or two sections are being pointed out saying that this is
Mm. Only one. That only the preventive part.
until and unless we are put to notice that this particular section,
Notice, yes.
this particular section, how do we even respond? Here the challenge is blanket challenge to the entire act.
Yes, yes.
And who is he? Your lordship will kindly see the description. In paragraph 1,
Mm.
vague statements have been made about the act.
Mm.
Then, if your lordship will kindly come to page 6,
Mm.
the only statement is
Mm.
at the very top.
Mm.
Further, the petitioner is not misguided by self-gain or achieving gain for and on behalf of any other person or any other institution, and there is no motive other than public interest litigation, so and so. Then your lordship will kindly come to paragraph 3(1).
Mm.
The petitioner begs to state that the instant PIL has been filed for the welfare of the state. What welfare? And to prevent operation of legislative bad law within the state of Arunachal Pradesh, the petitioner cannot, this sentence is very important, the petitioner cannot specify as to why other citizens are approaching this honorable court, regardless of the fact the petitioner being a concerned citizen has filed the instant PIL. And if your lordship will kindly come to, it is his own statement.
Mm.
If your lordship will kindly come to paragraph 28.
This, I think this matter was heard earlier also. Paragraph 28, yes.
Paragraph 28,
Mm.
he himself says that around 40 persons have been detained under this act. None of those 40 persons have approached this honorable court challenging the act.
Mm.
Your lordship is aware of the law. As far back as in SP Gupta's case, the Constitution Bench has said that what is a primary injury and what is a secondary injury? A person suffering a primary injury, these are the 40 people who have been detained under the act. They are the persons who have suffered the primary injury.
Yes.
It is for them to approach this court. If there is anything wrong with the act, it is for them to approach this court. He cannot represent them and simply claiming that I'm a social activist, he cannot come and file a PIL like this. Time and again, Supreme Court has made it very clear that a PIL cannot be used as an instrument for publicity. This is a public interest litigation. This is not a publicity interest litigation. This is a purely, my lord, he wants some media attention. He wants some publicity for himself. Maybe he wants to contest some election sometime. No other reason. Why will your lordship say?
Entire virus of the act.
Entire virus of the entire act.
Okay.
And now,
But we were pinpointed to certain sections. But it is
to
not there.
do
In the it
that,
is not there.
they have to make a specific pleading so that we can, as a state, we can give our justification as to why we have incorporated that provision. There's nothing, a blanket challenge to the entire act. Why will your lordship? There are judgments I can place straight away, which will show that this petition is not maintainable, and these kinds of petitions, your lordship will not only dismiss, your lordship will impose a very heavy cost for wasting your lordship's valuable judicial time.
Yes. Just a moment.
Lordship, I have uh,
Oh, Just a moment. Yes. Should be West. Should be very West. So we
ये वाला निकालो ना, ये वाला 2003 7 SCC 5. Yeah.
Lordship, regarding maintainability, actually this has already discussed, Lordship. Lordship, PIL, there is a one condition, then private injury and public injury, Lordship. That I am not challenging the private injury. I am challenging the,
No, I just want to ask you, are you challenging the entire virus of the act, or you are challenging only, in the beginning, I had this idea that you were challenging only this section preventive detention part only.
Lordship.
That not preventive detention part, that executive magistrate taking over the act of the judiciary.
Yes,
CRPC,
Lordship,
and
is
then the
also-
judge, difference between the sitting judge and the
Lordship.
retired judge.
Then-
That was the
Then Lordship, then
impression I had.
Lordship, that period of the detention, because when this condition is,
That prayer is that you are challenging the entire virus of the act.
yes, Lordship. Lordship, the meaning, Lordship, what I meant to say is, when these sections are void and illegal, then there cannot be any and then other rest section is they become useless, Lordship, because this three part is pillar of the
So
court.
you answer on the point of maintainability.
Lordship, that I am coming, Lordship.
In that case, my lord, your lordship takes up the maintainability.
Hmm.
Let me point out to your lordship how this is not maintainable. That will make it easier for him to respond.
Yes, yes.
Lordship.
On 2-3 counts, I'm questioning the maintainability.
Hmm.
First ground is, if your lordship comes back to paragraph 28,
Para 28.
para 28 at page 34.
Yes.
If your lordship will kindly peruse para 28, that the petitioner begs to state that ever since the Arunachal Pradesh Unlawful Act 2014 has been enforced,
Hmm.
the state become tool for the state government to suppress the citizen, etc., etc. And then if your lordship comes, your lordship may skip that portion.
Hmm.
Then there is a sentence starting, having stated in the
Yes, yes. This is
Having-
at page 29 for us.
page 29, correct.
Hmm.
Having stated in the recent APPSC paper leakage fiasco, same result have been witnessed in the state, wherein more than 40 persons have been arrested in the name of preventive detention by the state government, including underage person from their residence. It's the petitioner's own case that 40 people have been arrested under this Unlawful Activities Prevention Act.
Hmm.
These 40 persons have not challenged the act. So whether a third person by way of a PIL can challenge it. For that, my lord, there are direct judgments on the issue. If your lordship will kindly take up SP Gupta's case, my lord. There is a division bench judgment of our High Court also, and 1981 supplementary SCC 87.
Yes.
81 supplementary है सर. हाँ वो भी निकाल के रखो. And that one. नहीं. उसमें नहीं है। चलो इधर 66. Yes. 81 supplementary SCC, 87, para 25. In this case,
You have the book?
book list नहीं दिया क्या? ओहो.
It's okay, please read it out.
And what it says is, this is the case where the Supreme Court went into the issue that when a PIL is filed, it has to be firstly in public interest. Secondly, what the Supreme Court says is, let us say I, as Indranil Chaudhary, have suffered the primary injury. It is my personal grievance, but I choose not to come to the court. And on my behalf, my friend Mr. Tapin files a PI, or not on my behalf. He says that this is the wrong that has been, this is the public interest that has been violated. Your lordships will not entertain, because I am the person who has, Indranil Chaudhary is the person who has suffered the injury. Your lordships will not entertain a petition on behalf of Subhuta. That is the law that has been laid down. Para 25, this is how it reads, Mal. Before we part with this general discussion in regard to locus standi, there is one point we would like to emphasize, and it is that cases may arise where there is undoubtedly public injury by the act or omission of the state or a public authority. But such act or omission also causes a specific legal injury to an individual or to a specific class or group of individuals. In such cases, a member of the public having sufficient interest can certainly maintain an action challenging the legality of such act or omission. But if the person or the specific class of or group of persons who are primarily injured as a result of such act or omission do not wish to claim any relief and accept such act or omission willingly and without protest, the member of the public who complains of a secondary public injury cannot maintain the action for the effect of entertaining the action at the instance of such member of the public would be to foist the relief on the person or specific class or group of persons primarily injured, which they do not want. I am the person who has suffered the injury. I accept it. So, in such a situation, your lordship will not entertain a petition on behalf of a third person. So that is exactly what has happened. He simply claims that I am a social activist. He states in his own petition at paragraph 28 that 40 people have been detained. Those 40 people have accepted. They never challenged the act. So why will your lordships entertain that petition at his instance? Based on this, my lord, what had happened was, in Meghalaya, in the state of Meghalaya, a petition came to be filed. Yeah, public interest litigation was filed. Similar kind of a situation. There was a contract awarded without any tender. The other people in that business, no one approached the court saying that my right has been violated because no tender was flowed. One person again similarly comes before the court, files a public interest litigation, saying that I am a social activist, I am so and so. And this contract has been awarded without any tender. By applying this SP Gupta's principle, the writ petition was dismissed. That citation I'll give to your lordship.
Yes, yes.
Yes. मेरा नोट कहाँ चला गया? That citation is, my lord, 2004, volume 2 GLT 403. This is Wallapang Roy versus State of Meghalaya and others.
Spelling?
WALLAMPHANG Roy, ROY,
Mhm.
versus State of Meghalaya and others. In this case, by following the principle laid down by the Supreme Court in SP Gupta's case, the one that I read out,
Mhm. Paragraph?
the relevant paragraph should be. I'll
Please
just
note
check.
down these books, huh? You give me the printouts. Printouts.
पलक होना चाहिए था। I'll just give this. Paragraphs are 13, 14,
Mhm.
and 19, 21. In fact, entire SP Gupta is quoted in paragraph 7. The relevant portions of SP Gupta are quoted in paragraph 7. And paragraph 11 also is on locus standi. Now, therefore, my lord, my first ground on which I am challenging the maintainability of the writ petition is that the people primarily affected, people who suffered the primary injuries, are not even before the court.
Mm. Yes.
Therefore, your lordships will not entertain, because it is a PIL. Your lordship is aware how PILs are being misused nowadays. Supreme Court is now very clear that your lordships will not entertain frivolous PILs. The second ground on which I am questioning the maintainability is, as I was pointing out from the prayer,
Prayer, yes.
a blanket challenge to the entire act has been made.
Yes.
Now, we are not being even given an opportunity to defend. We do not know which particular provision he is saying is repugnant, which particular provision he is saying is ultra vires. We are not aware. Only during the course of arguments, he points out selectively that paragraph, section 7.
Yes.
Will your lordships allow an act to be challenged like that, where the state is not even getting an opportunity to defend, because there is no specific averment? So it completely lacks in pleadings. Now, the third limb of my argument is,
Mm.
there is a specific judgment of the apex court
Yes.
which says that your lordships will not entertain a challenge to a statute by way of PILs. There is a little bit of a confusion with regard to my citations, my lord. Bit of a handicap. Yes. The citation is 2003, volume 7 SCC, 546. And the relevant paragraph is paragraph 50, subparagraph Roman 11. Here, various guidelines and principles have been laid down in paragraph 50.
Mm.
And in this subparagraph 11, what the Supreme Court is just one sentence.
Yes.
Ordinarily, the High Court should not entertain a writ petition by way of a public interest litigation, questioning the constitutionality or validity of a statute or a statutory rule. Because the reason is again simple. Principle flowing from SP Gupta. But if someone is affected, he will himself come. If some person is specifically affected, he will himself come. Why will your lordships entertain a PIL challenging an entire act or entire rule? Now, my lord, the fourth ground on which I am questioning the maintainability is, your lordship is aware, after that judgment by the Supreme Court, I think it is, if I remember correctly, 2008, our authored by our own,
Yes.
one of our honorable judges, my lord, Justice M.K. Sharma, where guidelines pertaining to PILs have been laid down. Pursuant to that, your lordship is aware, our High Court has framed rules
Yes.
for filing PIL. Your lordship, I am not pointing out individually, I am not wasting your lordship's time. Your lordship will find that none of the provisions as given in the rules have been complied with. Particularly, Rule 10 of the Guwahati High Court PIL rules. And more specifically, Rule 10D, Rule 10F, Rule 10G, and Rule 10H. These rules, so framed by the Guwahati High Court PIL rules,
What will be the latest page number? We'll say, we'll get it, we'll check it out.
it is there in that Guwahati High Court rules.
The up-to-date rules?
In this particular book, if it is this book,
Yes, yes.
your lordship will find it at page 488. At Rule 10, your lordship will find how a PIL is to be filed, paragraph wise it is given.
Yeah.
Rule 10, instruction for filing public interest litigations. A writ petition intended to be a public interest litigation shall contain, it is mandatory. Then what are the requirements are given from A to J, my lord. And in this particular case, I am pointing out that Rule 10D, 10F, 10G and 10H have not been complied with.
Okay.
And I must also point out to your lordship that in a judgment of the division bench of our High Court, these rules have been held to be mandatory. And that citation I am giving your lordship. my lord.
Yes, yes. You have said, no, you'll give our division bench judgment?
Yes, my lord.
Yes.
These rules have been held to be mandatory. In 2017, Volume 2 GLT 443.
Okay.
And the relevant paragraphs are paragraphs 7 and 8. So non-compliance of these rules, your lordship will dismiss at the very threshold without entering into it. So these are the grounds on which I am questioning the maintainability. Let him satisfy that first. Before your lordship go into the merits of the
Yes,
case,
yes,
he has to satisfy your lordship that this writ petition is at all maintainable.
May lordship.
And in any case, my lord, even if your lordship holds it to be maintainable, he has to, that is my alternative argument, he has to amend the PIL and make it specific so that we are in a position to respond. Because now we are at the stage of hearing, suddenly he comes up that Section 7 is ultra-virus, Section 11 is ultra-virus. How do we even respond without knowing what the challenge is?
Lordship, regarding maintainability, actually this case has come this far, Lordship, actually. Lordship, from beginning of the PIL in 19, Lordship, this Khartoon Hussain, Lordship, it was in fact first PIL of the India also. That applicant was no one under the this NEJL, Lordship. And then, Lordship, SP Gupta regarding this scope of the FIL has been actually enhanced in SP Gupta Lordship. This has been misinterpreted by the Learned Council Lordship. Because regarding maintainability, this applicant was not even having any individual prima facie and did not suffer any suffer from the transfer and posting of.
Personal injury.
Yes, Lordship. Then here comes that, Lordship, may I come to the SP Gupta case, Lordship? Phase 200.
I'm sorry to interrupt, Madam. Can I be excused for
Yes,
5
yes,
minutes?
sure.
I'll just come back.
Lordship, for 1718 of the SP Gupta, this is clearly mentioned that if, Lordship, there is a frame, I am not going into the, Lordship, primary and secondary injury. I am going into the private and public injury, Lordship. Primary, the case which has been placed by the Learned Council, my senior, this is regarding the private and this secondary injury. I'm not about this, Lordship. I'm about the public and individual, Lordship, injury. Lordship, when
Only one question only. You were challenging the entire virus of the act?
Yes, Lordship.
Entire act.
Yes, Lordship. Because, Lordship, there is a judgment. If there is even 3 section is illegal, then entire act can be.
So you see, now they are saying that they are being prejudiced because they were prepared only for the entire virus of the act. And now you are pinpointing only 3 sections.
Lordship, this has been already this replied by them, Lordship. Because when my challenging apartment is complied by them, there is no question of that we are not getting the chance, Lordship. This is just deviation from the factual, Lordship. Maintainability regarding the submission of the maintainability, all this thing is just fact of the deviation from the actual fact, Lordship. When it comes into the constitutional validity, Lordship, judicial cannot decline, Lordship. This is a one case that after the case Bharti case, Minerva Mill, then SP Gupta, and then Golaknath, Lordship. This case is very important because in form of the public interest, Lordship, this is more important.
See, those are relating to basic structures of the constitution.
Exactly, Lordship, coming to this, Lordship.
Should we go there?
Exactly, Lordship, this is,
We are not going to interpret the
Lordship, in my part of the submission,
the constitution.
Lordship,
Maybe the act, not the constitution.
exactly, Lordship, I am coming to that in my, Lordship, SP Gupta, may I come to this paragraph 17 and 18, Lordship. Then it clearly that there was a question whether it was about the transfer and appointment of the judicial officer, Lordship. Because applicant was not a judicial officer nor this judge, Lordship. Then applicant come that because of the transfer and posting or constant transfer and posting of this judicial officer, that there is violation of the constitution. Then this condition has been admitted and accepted by the SP Gupta case. Then it come into the this argument was in that with the fact after the crossing of the maintainability, Lordship. There is SP Gupta is very clear. Lordship, regarding it is mentioned that if there is a public injury it means that there is a this act that violate the constitutional mandatory. Then who will be there to come forward, Lordship? This was the question. Because I am not about regarding the secondary and primary injury. I am regarding the injury of the individual and public. Public injuries, violation of the constitution is clear this condition of the public injury, Lordship.
Okay.
Lordship, there cannot be any maintainability, there cannot be no any question, Lordship. There is no any substance in the submission of this, Lordship. And then, Lordship, one of the very important question, here again, in Assam, Lordship, Bimo Lamsu Roy versus State of Assam, Lordship, it was in form of the FIL. One act has been challenged, Lordship. This is very important. 2018, 14 SSC, Lordship.
2018,
2018, volume 14 SSC.
page,
Page 400.
a party's name,
Yes. Party's name is Bimo Lamsu Roy versus State of Assam.
spelling,
BIMO LANSHU.
BIMO
LAN
LAN.
SHU and Roy, ROY, Lordship.
Okay.
Lordship, this is one FIL,
Versus state of?
State of Assam.
Okay. Yes.
Lordship, may I read to this
Yes,
operative
yes.
portion, Lordship?
Paragraph?
Lordship, paragraph, this is page number 414, Lordship.
Page 440.
Yes, Lordship.
Okay.
308. And again, 408 is.
408 also.
And then Lordship, operative portion is, last conclusion is. Lordship, last conclusion, 432 para 37. This is. Lordship, may I read this?
Yes.
Lordship.
Please note down the
Lordship.
quotations. Okay. We'll get
Lordship,
down.
as per the article, Indian Constitution, Lordship, 164A, 1A, the strength of the council minister was to be brought down from 19 to be inconsistent with the ceiling of 15%. Lordship, meaning thereby, number of, there's strength of the minister shall be 15% out of the total council, Lordship. Then Assam legislative brought one act. This is Assam Parliamentary and Salary Act, Lordship. They brought. By that, that provision give status of the minister to the rest of this Lordship, MLA. Because as per the Constitution, there is clear cut that strength of the minister shall be 15%. Then it was 31% as per this Assam Act. Then applicant was nowhere this council of the minister, then MLA. He was just a citizen, Lordship, because it was the public injury that when constitutional is mandated that there shall be 15% of the minister in the total council, Lordship. Then one nowhere where the council minister, because it was public injury meaning thereby constitution, mandate constitution is violated by the legislated act, Lordship.
Okay.
On that condition, same case, my case is, because here I am talking about the constitutional validity, because it encroached the constitution. And this case also, Bimalonsu versus State of Assam, this is same case, because he were personally and individually, he did not suffer. He was not a sufferer. But because of the public injury being violated to the constitutional mandatory, then this case was allowed and act was, Lordship, straight down, Lordship. This is the same case, Lordship. And Lordship, regarding the maintainability, that if you is, Lordship. And again, Lordship, SP Gupta is very clear case, Lordship. Because there was maintainability was questioned. When the maintainability was questioned, that court said that when there is a public injury, who shall be there come to protect the constitution? Then case was discussed on merit basis, not on the maintainability, because maintainability was admitted in SP Gupta. And scope of the PIL was this enhanced by the SP Gupta, Lordship. This is clear case. This has been misinterpreted by the this clearly. Lordship, regarding the maintainability, Lordship.
Okay.
And again, Lordship, actually, as per the rule of the this Guwahati High Court PL regarding, Lordship, there is no violation, because personal interest, there is no any personal interest, background has been given, qualification has been given, occupation has been given, address has been given, and pro forma has been given in affidavit, Lordship. May I come to the Lordship affidavit? Lordship, pro forma is given. And there is a discretion of the judge also in this condition. Condition is given in FIL, rule for the FIL in Guwahati High Court, Lordship. Because there is no any violation, Lordship. This is just deviation text, Lordship.
Okay.
And Lordship, now coming to the why this suffered the public injury, Lordship. Lordship, regarding why this has been challenged, Lordship, entire act. Because when detention period is void and illegal, there cannot be act, Lordship, because detention period is core provision of the act, Lordship. And advisory board is core provision. Any one of this section is Lordship, illegal, void, and this ultra virus, Lordship, all act remain, Lordship, useless, Lordship. And Lordship, regarding this case placed by my senior, it was file was rejected for the this tender purpose. Tender is not public injury. There is no any public injury. There is no any violation of the constitution, this fundamental right. Maybe constitutional, Lordship. So it was rejected, Lordship. It was context is totally
So
different.
according to you, the detention period, you have said something about detention period?
Lordship, when detention period is more than 3 months, then bill has to be passed before the governor of the state. Then it is mandatory, Lordship, legislative procedure. When this detention period is more than this 3 months, then bill has to be placed before the Lordship President of India, who is this constitutional head of the nation, Lordship. Because
It will be article,
Lordship, may I say Article 31C, 31C, Lordship. No, Lordship. 31C, Lordship. May I come to the Constitution, Lordship? Again, this is very one of the Lordship, important article, Lordship. 31C. Lordship, 31C, Lordship. Lordship, may I read?
yes.
Saving laws giving effect to certain directive principle, not with understanding anything contained in Article 13. No laws giving effect to the policy of state towards securing all or any of the principle laid down in the Part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any right conferred under the Article 1419. And no law containing a declaration that is for giving effect to the shall be in question in any court on the ground of it does not give any effect. Lordship, this is for the Parliament Act. Then there is a condition, provided that where such law is made by legislature of state, the provision of this article shall not apply unless thereto unless such law having been reserved for the consideration of the president and has received his assent, Lordship. This is clear constitutional violation that there is, Lordship, constitution is mandated that 3 months is mandatory, Lordship. And then sitting judge is mandatory. When this is not followed by the state legislator, then law is made in pursuance to the directive principle of the state policy, Lordship. Part 4 of the Indian Constitution. Because Part 4, Lordship, there, as per the Minerva Bill, there should be parallel this invocation of the fundamental right and directive principle. But state has always override the fundamental right, Lordship. But even if override this fundamental right, that state law should be assented and considered, and it must be mandatorily and by provision of the Constitution, mandatory Constitution, that is this bill has to be placed before this President of India, Lordship. And this assent of the President is, Lordship, legislative mandatory. This has been decided in one case also, Lordship. Then this is clear violation of the Lordship that any provision that state can detain the person, its own citizen,
So
beyond the
it's fine, you have a point. You
Lordship.
have a
Then,
point, but you see, again, he has been submitting over and over again that
then Lordship,
when
then
particular points were pointed out, he was not given a notice to answer on that point. So
Lordship,
he couldn't reciprocate.
Lordship, this I leave it to the wisdom of this honorable court. Lordship, as per my environment, let me go into the environment, Lordship. I have clearly reflect.
Because now you have pointed out certain, not the entire act.
Then when, Lordship, there is a one case that
Certain infirmities between the
Yes, Lordship, then-
constitution and the act.
regarding that,
The manner
that
in
one
which
is,
the act was passed.
yes, one judgment, Lordship. Lordship, one more. Ismail Farooq versus Union of India, 1994.
1994?
Ismail Farooq versus Union of 1994, Lordship. Volume 6.
Yes.
Volume 6 and page
SEC?
436. 436, Lordship, 436.
Volume 6,
Volume 6,
SEC,
SEC,
page
page 436, Lordship.
436. Farooq will be ROOQUE.
Lordship, FARUQE, Your Lordship. Ismail Farooq versus Union of India, Lordship.
All right.
Lordship, Farah 136, page number 436.
Yes.
Lordship,
Para what? Which number?
Farah 136, Lordship. That, Lordship, may I read, Lordship? The core provision of Act are section 3, 4, and 8, Lordship, 3 section. The other provision of the Act are only ancillary and accidental to section 3, 4, and 8. Since the core provision of the section 3, 4, and 8 are unconstitutional, the Act itself cannot stand, Lordship. Lordship, why I am challenging this? My challenging provision, when it is struck down, there cannot be Act, Lordship. This is where, Lordship, and my apartment is very clear, Lordship. And Lordship, this is clear that when
Yes.
this and 3 provision is,
Yes.
Lordship.
I have noted down everything. Anything else?
And Lordship, yes, Lordship. And Lordship, in my Lordship, there is an advisory board is, Lordship, it is illegal, and then cartel of practitioner right, Lordship, that under the APWAPA, as per the section level 4.
11.4.
Yes, Lordship. Lordship, level 4, that, Lordship, detainee cannot be represented by a legal representative, Lordship, even in advisory board, Lordship. This is completely hit the fundamental right of 14 and 19, Lordship. Because my fundamental right, Lordship, cartel, read. Lordship, as per the section level 4, that, yes, Lordship, that is detainee cannot be represented by the advocate and his choice of Lordship, this legal practitioner. Lordship, there is a judgment, Lordship.
Yes.
Where in your petition you have pointed out this?
Yes, Lordship. Page.
This is not pointed out. Specifically, he is not pointed out.
Lordship, Farah 13, Lordship. May I?
Para 13 in the
Yes.
petition.
Yes, Lordship.
Okay.
Lordship, the petitioner begs to state that as per the provision of the Unlawful Activities Prevention Act, under the level subsection 4, it is mentioned that any person against whom detention has been not allowed to
Okay.
appear,
Yes,
Lordship.
yes.
Lordship, there cannot be any law that one,
Yes, yes. I got your
Lordship,
point.
then
He
if,
has to be represented by. a
exactly, Lordship,
magistrate.
if this has also passed, Lordship, by virtue of the this directive principle of the state policy, then this law has to be mandatorily placed before the President of India, Lordship, because this principle is, Lordship, why this is so, Lordship, that public injury, any act is not above the supremacy of the Constitution, Lordship. Supremacy of the Constitution is basic structure of the Lordship, our Constitution. So any act passed by the state legislation cannot be above the this supremacy of the Constitution, Lordship. So if there is any case that it is just level and above the constitution, then this law is not this lordship considered by governor of the state. It has to be considered by the president of
Yes.
nation, lordship.
Mm.
This is exactly what I, lordship, shown in Article
Yes, yes.
13 and 13C. And lordship, there is a one provision,
13,
Article this 31C.
31.
As per 31C,
Yes, yes.
any law, because lordship
No,
fundamental
no,
right.
you have pointed out Article 31C.
And again, lordship, lordship, detention is beyond this constitutional mandate. And then section 15 and 17,
Hmm.
2 years punishment and 1 year punishment by the executive magistrate, lordship. Executive magistrate. Because there is no any court. Because lordship, natural principle, this one who has never been tried before the court, one who has never been heard, and one who has never been given opportunity of defending his case, lordship, then punishment is there. Lordship, this is called basic structure. There comes, lordship, that one executive magistrate cannot come that extent, lordship, because if there is a provision, it is just on because of the, again, directive principle of the state policy. Then whenever this provision is again invoked, then president has to be assented, lordship. So this law is void, illegal, lordship.
Okay.
And there is a clear, and lordship, there is, as per the article, lordship, again, even 200, lordship, there is a mandate constitutional provision that any act
Yes,
that
yes.
if it negate the provision, then sanctity of the High Court, lordship, then again this act has to be on particular on that ground also. This act has to be considered by the President of India, lordship, because it is this law. It is against the Constitution of India. So state government is not, lordship, given, and state legislature is not given, lordship, that extent of the power, lordship. So there is a concurrent list. And lordship, may I come to my judgment, lordship, why this is strike the basic structure of the Indian Constitution?
Judgment on basic structures of.
Yes, exactly.
No, not required, I think. Basic structures of the constitution.
Lordship,
Maintainability matter.
lordship, maintainability, I have already, lordship, this satisfied this honorable court by placing the judgment.
Which
lordship.
judgment? Basic structures of the
No,
constitution.
no, lordship,
Which
this maintainability,
judgment?
maintainability. Because
Maintainability, yes.
That for the fuel coin also,
Yes, you have submitted on maintainability, yes. We have asked him on and over and over again, he has submitted on maintainability, but we won't go there, basic structures of the
no, lordship, that,
constitution.
no, no, lordship, lordship, that,
This is not required, I think.
again, lordship, one condition is, lordship, while this is against the one,
Basic structure of the constitution, this is required. Okay, yes, yes.
lordship,
You can
yes,
go
lordship,
ahead.
and one,
Which judgment you want to rely on?
lordship, exactly, Kesananda Bharti, lordship, Kesananda Bharti case, lordship.
No.
Lordship, again, one condition that if their law seems to be derogate the constitution violation, it is placed under the 9th schedule, lordship. 9th schedule, when this any law is placed under the 9th schedule, it cannot be challenged, lordship. This has not been even accorded by the state legislative. Under the 9th schedule, more than 200 act, lordship. When this seems to be derogate the constitutional mandatory, this is placed before the 9th schedule. And this has not been, again, that accorded by the state legislature, lordship. So there is no any constitutional mandatory has been accorded by this legislature, lordship. Now, lordship, why this is against this, lordship, basic structure start from the, right from the exactly 1973 Kesananda Bharti. It was challenging the Kerala Reform Act, one act. When one act was challenged, then formation of judicial, formation of the basic structure was done, lordship. Exactly, this case is similar to
Which paragraph? I understand that land of the mandir you're talking about.
Lordship, lordship, may I come to the case of Bharti, 1973-14, lordship.
1973?
1973.
I'll get it.
Uh,
Just quote the paragraph. It is a long judgment,
Yeah, exactly. Lordship.
700 pages or 800 pages. I'll get it.
Yes,
Just
Lordship.
quote the paragraph.
Lordship, paragraph 648.
Hmm.
And Lordship, 292, Lordship also, 292.
Hmm.
May I read out the basic structure, Lordship? Because how, Lordship, during supremacy of the Constitution and republic and democratic form of the government, secular character of the Constitution, separation of power between legislature and executive and judiciary, Lordship. This is exactly. And again, the supremacy of the Constitution. Lordship, Lordship, as per Kesavananda Bharti, Lordship, when this one act was challenged by the Kesavananda Bharti in 1973, then fundamental rights, even if there is an amendment of the Constitution by the Parliament, it can, in fact, amend the fundamental right, but it cannot amend the basic structure, Lordship. That as per
That's why
Kesavananda.
I'm saying it's
Yeah, Lordship.
required.
So, Lordship, now the AFWAPA, section 82, 83, 84 is for the criminal case, Lordship. And
That
prevent-
I understood, yes.
Lordship, that on that principle, this law is completely against the basic structure, Lordship.
Hmm.
Because those section is that exercised by the this judiciary,
Hmm.
and then there is no any condition that reporting the judicial magistrate, Lordship. So this is against the basic structure, Lordship. And then, Lordship, and Lordship, this one case, Indira Gandhi versus Raj Narayan also, Lordship.
Hmm.
There is also clear the similar 1975 supplement, Lordship, 1975 supplementary and SEC.
Hmm.
Lordship, 39 amendment 75, Lordship.
Hmm.
This, Lordship, how this relate that as per this 39 amendment by the Indira Gandhi government, that election of the prime minister and then speaker and president cannot be challenged before the judicial this court, Lordship. Then Supreme Court has clearly stated that if there is jurisdiction of the judicial is not given in any law, any amendment, this is against the basic structure. Then this 39 amendment was struck down by the Supreme Court, Lordship. In the same way, how APOPA, this judicial, this jurisdiction of the judicial is not given. And then regarding this constitution of the advisory board, there has to be this sitting judge, Lordship. Not at all jurisdiction of this judiciary is given. Then on that context, even if Parliament amend the constitution by its own this provision, then this act and law is struck down by the Lordship, Supreme Court, Lordship. In the same way, Lordship, because as per the 39, that election of the Prime Minister and Speaker cannot be challenged before the this Honorable Court, meaning thereby jurisdiction of the court was deleted from the provision. Then Supreme Court interpret because it is against the basic structure. Then this 39 amendment was declared void and illegal, Lordship. And again, Lordship, Minerva Mill is already there, Lordship, regarding.
It's okay, it's okay.
And Lordship,
It's okay. It's okay, I got your point.
yes, Lordship, there is, Lordship, again, Lordship, one of important is state of Tamil Nadu versus state of Kerala.
But you give me the relevant paragraph in this Indira Gandhi versus Raj Narayan.
Yes, Lordship, Raj Narayan. Yes, Narayan, Lordship. Raj Narayan. Lordship, this is in last portion itself,
Okay.
Lordship, right, Narayan.
Okay.
Basically, it was regarding, and Lordship, again, Lordship, state of the Tamil Nadu versus state of Kerala,
On
Lordship.
which point? See, you see,
Lordship,
inconsistencies between the state laws and the legislature, parliamentary legislatures. So inconsistencies you are pointing out, I got your point. So
and-
I don't need so many judgments.
Okay, Lordship, then regarding the separation of the judicial and Lordship, this executive, this is judgment, Lordship.
Separation of judiciary and executive.
Yes, Lordship.
You want to submit that judgment also. Why is it required?
Lordship, because,
It's only because of a virus of the act you are challenging. Why is it required? that
Lordship,
judgment?
that article,
Is it relevant at all, that judgment, separation of powers?
Lordship, because sections 82, 83, 84 is encroached into the
Okay. on
judicial.
that,
Then
yes.
on that front,
Yes, yes.
Lordship, state of Tamil Nadu versus state of Kerala, 2014, 2014, volume 12, phase 696,
2000?
2014,
Yes. SCC,
SCC,
2014 volume,
yes, volume 12,
SCC,
SCC, and again phase 696, SCC, yes, Lordship,
page, SCC,
phase
page
696,
696,
Mm.
state of Tamil Nadu versus state of Kerala.
yes, Lordship, again 699, Lordship,
Mm.
that independent of the court,
Mm.
Lordship, may I read? Independent of the court,
Paragraph,
para, Lordship, Malin,
thereafter you conclude.
yes, Lordship. Lordship, this is in the first sphere, Lordship. State of Tamil Nadu, Lordship.
First paragraph.
Lordship, 10, para 10, Lordship.
Para 10.
Yes. 10 D.
10
D.
D. Small d.
Yes, small D, Lordship. Lordship, may I read, Lordship? Independent of the court from the executive and legislature is fundamental to the rule of law and one of the basic tenets of the Indian Constitution. Separation of the judicial is significant constitutional principle under the Constitution of India. Lordship, that breach of the separation of the judicial power may amount to negation of equality under Article 14. Such legislation can be invalidated in under Article 14, Lordship. Because if this principle of the separation is breached by any law, this can be negated, Lordship. This is clear, Lordship.
Okay.
Lordship,
Alright.
regarding this advisory board, Lordship, this is one
Advisory board, yes.
advisory board. This is one of the Lordship advisor A.K. Rai versus Union of India.
A.K. Roy.
Versus Union of India,
Okay.
1982,
Mhm.
and volume 1,
Mm.
phase 227,
SCC,
SCC, Lordship,
227.
227,
Paragraph.
paragraph 87,
Mm.
93, and level paragraph also, Lordship.
Hmm?
Lordship, paragraph 87, 93,
Mm.
level. Lordship, as per this, Lordship, advisory board, because Lordship, advisory board is very important. Sometimes this preventive detention law is misused by this state, because state is this under the guidance of the legislature, Lordship, legislative, and legislative is none other than politician, Lordship. There is some situation time that this is used by this best example is 1973 Emergency Act, Lordship, emergency period. Lordship, MISA Act was Lordship, during the emergency period, that more than
No, it's okay.
Lordship, then as per the 44 constitutional amendment, that it was discussed that the provision requiring advisory board to be constituted accordance with the recommendation of chief justice and appropriate high court, and chairman of the advisory shall be serving high court, judge of the high court, Lordship. FARA 100 level, Lordship. Because there has been,
All right.
Lordship, this is
Para 100,
110 level, Lordship.
so the chairman has to be serving judge of the High Court.
Yes, Lordship. And 44 amendment in 1979, Lordship.
It's okay. Please conclude. Others will get confused now.
Yes, Lordship. Again, Lordship, one of the important is,
Now we will get diverted to something else.
yeah, exactly, Lordship, sorry, Lordship. And Lordship, yes, Lordship, Francis, that, Lordship, this represented by the advocate, Lordship.
Hmm.
This is,
Yes. Representation by advocate.
yes. Lordship, presently. Lordship Francis Carolina versus Moulin versus
Francis,
Caroli Moulin.
spelling?
CAROLIE.
Oh, okay. Versus?
Moulin MULLIN.
Okay. Citation?
Citation, Lordship, 1980, Volume 1 SEC,
Page?
page 609.
And then paragraph?
FARA 4, level 12.
4, 11 and 12.
Yes.
Yes. Okay. Enough.
I don't know how to respond and what to respond to. I will just point out two things, madam.
Yes.
If your lordship will kindly come to Article 22.
Yes.
How this entire petition is totally misconceived, I'll point out.
Yes.
Just two quick responses, madam. If your lordship will kindly come to Article 22,
Yes.
subclause 4.
Yes.
No law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless A, my learned friend is harping on this,
Yes.
an advisory board consisting of persons who are, or have been, or are qualified to be appointed as judges of the High Court. So not only sitting judges,
Sitting judge, yes.
who have been judges means retired judges,
Yes.
or who are qualified. Otherwise qualified, even he can be appointed. So where is it said that only a sitting judge has to be a chairman? Now, I don't know how Article 31C was brought in. There's no applicability whatsoever. Your lordship will kindly come to Article 31C. This entire petition is totally misconceived. I did not want to respond on merits. This 31C, the heading itself makes it very clear. Saving of laws giving effect to certain directive principles.
Yes.
Fundamental rights are part 3 of the Constitution.
Yes.
Directive principles are part 4 of the Constitution. Your lordship can now look at the provision. Notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing all or any of the principles laid down in part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or 19. Article 21 and 22 are not even referred to there. This entirely pertains to part 4 of the Constitution. If your lordship will kindly see,
Yes.
part 4
Yes.
entirely pertains to directive principles,
Yes.
and Article 21 and 22 are are under part 3 of the Constitution. Entire writ petition, entire PIL, well, is totally misconceived even on merits. In any case, well, this is, as I've demonstrated before your lordship, this
Yes,
petition
yes.
is not maintainable on 4 grounds.
Lordship, core submission, Lordship, I have filed
No.
the additional, Lordship.
Not again.
Lordship, just the,
No.
Lordship, this has, Lordship, core Lordship submission, because it
But
is,
we'll defer it to another date.
Lordship, may,
Tomorrow.
Lordship, may,
Not again.
tomorrow, Lordship.
You won't be here. You'll be here tomorrow. How long will you take? Not again. It's okay.
Yes,
You
Lordship.
want to-
No, no, Lordship. This is National Security Act is.
No, 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 no.
No, Lordship. This is.
National Security Act is
No.
completely different. It pertains to national security.
No,
This is-
Lordship.
this
This
part-
comes under the concurrent list, Lordship. And then this comes under the concurrent list. And this is inconsistent with the National Security Act, Lordship.
You have said in the beginning, this act is inconsistent with the.
Yes, Lordship. This is this additional affidavit, Lordship. I am.
You have filed an additional.
Yes, Lordship.
affidavit.
I am fine. I am fine. Lordship, this is, Lordship, it will be this.
I'll go to the additional affidavit. I won't hear anymore.
A bit of 254.
Lordship, and next, that I may allow to submit this because this is very important, Lordship. And my,
Maybe, take it up some other day, tomorrow, maybe. You'll be here tomorrow.
I'll be here.
You'll be here. Then
Yes,
tomorrow.
yes, Lordship.
Yes, we'll continue till tomorrow then. Can you give me 5 minutes break?
Yes.
Obliged, Lordship.
I'll come back and pass an order. We'll continue till tomorrow. Mr. Yunis? G. Kato. Mr. Learned Counsel, Mr. G. Kato is present for the petitioner. Mr. I. Chaudhary, Learned Additional Advocate General.
Advocate.
Arunachal Pradesh is present for the respondent state. Part heard, argument list on tomorrow. Otherwise, maybe you will leave tomorrow.
I'll leave tomorrow.
Okay. We can complete, we'll complete it tomorrow.
Item number 7.
Please arrange it serially and tag it.
Implement of the charge again.
Yes, yes. Ready?
Find the required paper. One.
Yes.
Prosecution's version of the story is letting out of this find
Mm.
find out the 701.
One Lordship. So I am reading the FIR, Lordship. I have the honor to inform you that Sri Atungpa Jibiso, Lordship, he is the
Paper book, page 1 of the paper book.
Lordship, yes,
Okay, all right. Continue, please continue.
Lordship, was married to Lukidas, who is the prosecute me, Lordship.
Mm.
They have relied on the confessional statement.
Mm.
It was recorded under 164 CRPC. And there was a recovery of a wooden block, Lordship, which was marked as exhibit, material exhibit S5, Lordship,
Mm.
on the basis of the disclosure made by the accused, Lordship, under section 27 of the Indian Evidence Act, Lordship, which is marked as Prepper Exhibit 2, Lordship. And also, the prosecution has relied upon the testimonies of the landlord, Lordship,
Mm.
which is who was the prosecution witness number 3
Mm.
and informant prosecution number 4,
Yes.
witness number 4.
Mm.
And also the medical evidences from PW5, Lordship, who is the medical officer, Lordship. And PM report, paper exhibit 6, Lordship.
Now, Lordship, my submission before your Lordship is, Lordship, that the session judge has unshaped and based on the misreading of evidence and selective acceptance of contradictory testimonies, Lordship, and reliance on the retracted confession, they have convicted me, Lordship, for life imprisonment. Now, my ground of my appeal, Lordship, against the conviction, Lordship, now the prosecution has completely relied upon the confessional statement, Lordship. Now, Lordship will find a confessional statement starting from page 57 of the paper book, Lordship.
Okay.
Now, my contention here, now, plain reading of this confessional statement, 164 CRPC, under 164 CRPC, Lordship will find the operating portion at page 61, Lordship, of the paper book, Lordship.
Yes.
Now, here in this confessional statement, Lordship will find that nowhere I have confessed that I have hit the victim on the forehead, Lordship, or head. Page 61, Lordship, is the second paragraph, is the operating Lordship portion. On 27/10/2021, as usual, I came back home at around 6 p.m. from the garage workshop. I did not find my wife in the house. I waited for her. Finally, she came back home fully drunk at around 8:30 p.m. or so. She was completely drenched. She had injury marks on her head and hand. She was already having injury on her head and hand, Lordship, already before coming to the house, Lordship. It appeared that either she had fall or a fight. She told me that she had headache. I was angry at the same time. I told her that I would take her to government hospital. But she was adamant and was not listening to me. Somehow I managed to change her clothes and made her wear t-shirts and half pant. Thereafter, I lifted her on my back and asked her to remain calm and not to be adamant. She did not listen and was rudely behaving. Out of disgust, I brought her down on the bed and picked up a wooden piece of about 1 feet or so that was lying beside. I hit her on thigh 3-4 times.
I've read it. It's okay.
Lordship. Here, the confessional statement is in regards to hitting on the thighs,
Yes.
not on the head, Lordship. Now, the post-mortem says otherwise, Lordship. The post-mortem says that the cause of the death was due to brain hemorrhage, Lordship. The injury caused in the head, Lordship. Now, they are relying upon this confessional statement. Now, in this confessional statement, I nowhere say that I have hit her on the head, Lordship. Now, in the injury report also, Lordship, the hitting on the thigh 4 times, the injury is there, Lordship. She then picked up a dowel and cut her hair, Lordship. Then I slapped her.
It's okay. I've read it. We've read it.
Now, here in this confessional statement, Lordship will also find that before she came back to the house, Lordship, she was already injured. That is my statement in the 164, Lordship. That may also be kindly be noted, Lordship. And now regarding the cut on the hair, Lordship, the prosecution says that the hair was cut by me, Lordship, by using dowel, Lordship, which was seized also, Lordship. Dowel, wooden stick, those were part of the seizure list, Lordship. Now the dowel was used by my wife, not by me, Lordship. That is very clear in the 164 statement. Lordship will, as I have submitted, Lordship, the cause of the death, Lordship will find it at page 27 of the paper book, Lordship. down below, Lordship.
Yes.
Opinion of Assistant Surgeon, Sub-Assistant Surgeon on cause of death, Lordship. Lordship will see death due to brain hemorrhage, Lordship.
Yes.
Now, their case is, Lordship, prosecution's case is, Lordship. They say that I have used wooden stick to hit my wife on the head, and due to that was the reason of cause of her death, Lordship, due to brain hemorrhage, Lordship. Now they have relied upon the statement of mine, Lordship, of this 164 statement, Lordship. But then, Lordship, we have read it, Lordship. In the 164 statement, nowhere I have stated, Lordship, that I have hit her on the head, Lordship. That is my first ground. My second ground, Lordship, is on the medical evidence, Lordship. Now, the prosecutions, they have completely failed to link to the act of the death, Lordship.
Okay.
Now, here the prosecution's case requires proving that the accused caused the brain hemorrhage, Lordship, as I was submitting, Lordship. Now, defense, Lordship, I was examined as DW1 also, Lordship, and then the 164 statement, Lordship. Now, dear Lordship will have already seen, Lordship, I have clearly stated that before coming to the house, Lordship, she might have, since she was completely drunk before coming to the house, Lordship, coming back to the house,
Yes.
she might have fallen somewhere, Lordship, and got injured. Now, Lordship will see the statement of the doctor, Lordship, page 37, Lordship.
Yes.
Here, Lordship, during the cross, the doctor, Lordship, he is clearly opined, or rather, the doctor has clearly admitted in the cross examination that he has clearly admitted that fracture may be caused due to falling, Lordship. Page 38, Lordship. I'm reading the, Lordship. I have not specifically mentioned the age of the injury of PME. The sign of the dead body pressure of the rigor mortis shows the age of injury as 12 to 18 hours. I have not mentioned about the nature of the weapon used in PME report. The nature of injury present in the body cannot be caused by falling. Fracture may be caused due to falling, Lordship. This is important, Lordship. Now, this admission of the doctor, Lordship, during the cross clearly can be presumed that, Lordship, the deceased was the cause of her death was due to the falling, Lordship. Since she was already very drunk and she was injured already before coming to the house.
Accidental in nature.
Lordship.
It is not a fact that the death is accidental in nature. That is the doctor's statement.
Lordship. Now, my second leg of argument is, Lordship, one more point, Lordship, is regarding the recovery of the weapon, Lordship, used, which was marked as material exhibit 4 and 5, Lordship. Now, this particular weapon that was said to have been used by me, Lordship, was never sent for the forensic report. was never sent for forensic test, Lordship, to extract my fingerprints and all, Lordship. That was never linked. Now, material exhibit 4 and 5 is the 4 is the dowel, and then the material exhibit 5 is the piece of the wood, Lordship. That was never sent for the forensic, Lordship. Now, on what basis the prosecution is trying to link, Lordship, me of using the dowel, Lordship?
It was recovered from based on the disclosure statement and led by you only.
Lordship, but then that very disclosure was retracted by me, Lordship, in 313, Lordship. Lordship, I'm coming to that.
Yes.
Now, Lordship, my third ground is on the seizures and recoveries, Lordship. Now, in the entire, my argument is, Lordship, the seizure procedure is vitiated by procedural illegalities, Lordship. Now, well, the seizure was done, Lordship. Lordship will. There was no independent witness, Lordship. Now, PW3, he is said to be the independent witness as per the prosecution's story, Lordship. His name is, Lordship, Sito Jibiso, Lordship.
Okay.
Page 34, Lordship. Page 34 is the deposition made by PW3, Lordship. Well, crossing, Lordship, he has clearly admitted, Lordship, I'm reading the relevant portion, Lordship. Page 34, second paragraph, Lordship.
Yes.
Accused has not admitted before me regarding the murder before arrival of police. I was shown the material exhibit at PS, Lordship, police station, not in the place of occurrence, Lordship. During the time of obtaining my signature on seizure memo, I have not seen police recovering the seized material from the PO, Lordship. Now, as I was contending, Lordship, there are procedural lapses, Lordship. Now, IO was examined as PW6, Lordship.
Yes.
Page 42, Lordship. During the cross, last line, Lordship. Page 42, last line, Lordship.
Yes.
Yes, the IO of the case has clearly stated that it is a fact that these articles were not sent at FSL, Lordship.
Yes, yes.
It was never sent to the FSL. He has clearly admitted that, Lordship. And moreover, Lordship, page 43, Lordship, the IO of the case has clearly also mentioned about improper use of section 27 of Indian Evidence Act, Lordship. That memo was not properly done, Lordship. Page 42, Lordship, first line, Lordship. The IO of the case has clearly opined, Lordship, during the cross, Lordship. Though I have recovered the weapon of offense as per disclosure of accused, I have not prepared the disclosure memo under section 27 of Indian Evidence Act, Lordship. Now, the IO has clearly stated that he has not prepared this disclosure memo under section. So, this cannot be relied upon, Lordship, section 27 also. Lordship, my fourth ground is on witnesses and testimonies, Lordship. Now, as I have already submitted, Lordship, altogether, Lordship, 7 witnesses were examined, Lordship. Now, none of the witnesses are the eyewitnesses, Lordship. It is being clearly admitted by the IO itself, Lordship.
Yes.
And in the charge sheet also, the IO of the case, in the prosecution story, he is clearly stating that the conviction, the prosecution story and is clearly based on purely on the circumstantial laws. Now, coming to the witness, Lordship, prosecution witness number 1, Lordship. She is Srimati Jam Miji, Lordship, who is the neighbor of the deceased and the convict, Lordship. Now, if Lordship will find the deposition at page 29, Lordship, of PW1, Lordship.
Yes. This is PW6, page 39.
Page 39, it's PW1, Lordship. Page 29, Lordship.
29.
29.
Okay.
Now, PW1, as I've been containing, Lordship, no eyewitnesses, Lordship. In her deposition and in the cross, she has clearly stated that she has never seen the husband assaulting her, Lordship. And interestingly, in the cross, Lordship, page 29, Lordship, last line, Lordship, rather he has opined that it might be true that the deceased might die due to illness, Lordship. Since she was the neighbor, Lordship, she must have been knowing about some illness about the deceased lady, Lordship. These are all witnesses, Lordship, which cannot be relied upon, Lordship. And PW3, Lordship, Sito Jibisho, Lordship. She is the Gambura of that village, Lordship. In the chief, Lordship, if we go through his deposition before the court, Lordship, in the chief, he has clearly stated that the accused has admitted of killing his wife, Lordship. Now, in the cross, he has retracted that, Lordship. Page 34, Lordship, relevant paragraph 2nd line, Lordship. Accused has not admitted before me regarding the murder before arrival of police. I was shown the material exhibit PS during the time of this line is important, Lordship. Accused has this statement, Lordship. Accused has not admitted before me regarding the murder before the arrival of the police. So, the PW4, Lordship, page 35.
Yes.
In the cross, Lordship, page 36, Lordship. Third line, Lordship. I did not have any information regarding quarrel between accused and Luki, Lordship. I cannot say whether accused has murdered Luki or not. It is fact that Luki Das used to consume alcohol drinks. I cannot say if Luki Das has died due to alcohol drinks. It is not a fact that I have given the false FIR.
Okay.
Now, PW4 is the informant here in this case, Lordship. Our last ground, Lordship. Now the prosecution, Lordship, in the entire case, Lordship, the prosecution, or rather the IO of the case himself, has admitted to that fact that there is no intention, Lordship. No motive or intention, Lordship. The prosecution has utterly failed to prove that there is an intention, Lordship.
Okay.
Now, whatever injury, Lordship. Now, I am admitting that I have bitten her on the thighs, Lordship. That too is on account of sudden quarrel, Lordship. Not out of motive and all, Lordship. Sudden provocation and then quarrel between the husband and a wife, Lordship.
Okay.
Now, my final submission is, Lordship, the chain of, Lordship, here in this case, Lordship, the chain of events, Lordship will see that the chain of events are broken in every stages, Lordship. No FSL report, Lordship. No eyewitnesses, Lordship. No motive, Lordship. And the prosecution has relied completely on Section 164, the confessional statement, Lordship.
Yes.
And in that, Lordship has seen it, Lordship. In the entire 164 statement, nowhere I have stated that I have hit her on the head, Lordship. Now, my submission is, Lordship, at the best, this is a case of a grave suspicion, Lordship, not to be prosecuted under Section 302 of Indian Evidence or in IPC law. That's all.
Okay.
Okay.
May it please, Your Lordship. Your Lordship, as my learned brother has clearly submitted that this case is based on circumstantial evidence. So question of eyewitness doesn't come at all. That part goes. Now, so far as Your Lordship, his grounds are concerned, my Lord. On legal aspect, my Lord, I will make the submission, then I will come on the material fact of this case, my Lord. So far as FSL is concerned, my Lord, it is well settled. It's just a corroborative piece of evidence, my Lord. Non-sending of FSL may be a defect from the part of the investigation authority, and that cannot be result in acquittal if there are sufficient material to convict the accused, my Lord. This is the law. And so far as, my Lord, the seizure is concerned,
Yes.
Caesar is concerned, my Lord, he is an independent witness, even though, my Lord, it is again well settled, even in presence of police, the Caesar cannot be discarded. They have to establish that there is a motive to falsely implicate in the case. So it's very clear. Even if it is done by the interested witness, they have to demonstrate it during the cross-examination. And so far as, my Lord, the statement of IO is concerned, that whether it was done in accordance with the Section 27 or not, that would be the finding of this court. There are so many instances where IO says it is an incomplete charge sheet, but it is the court to decide whether it is a complete one or incomplete one. And moreover, my Lord, even if 27, assuming that 27 goes, but conduct is there, my Lord. The doctrine of confirmation by subsequent event, my Lord, that is always be there. Now I will come to the merit, my Lord. My Lord, may directly come to the star witness is the PW3, my Lord, the owner of the house. May I read the statement, my Lord? And my Lord, before that, my Lord, I would like to, Your Lordship, again, on the cross-examination in chief, my Lord, it is well settled again, my Lord. The witness must be cross-examined in all part of his chief which is intended to be disputed. Otherwise, whatever he is stated is accepted to be true, my lord. Now I will start with this statement, my lord, the chief. My resident is at Upper Balokpung, my lord, page number 32. Upper Balokpung, and I am a Gaobura of my village. Accused is standing on the dock, namely so and so, used to stay at my residence with his wife. They stayed at my residence for about 1 week. On the date of incident, I was not at my home, as I was invited in the residence of another person of our village. Now, my lord, this is to be noted. At about 11 p.m. in the night, I came back. He came back at 11 p.m. to my residence and seen that the room of so-and-so was locked from inside. I thought that they might have slept. Accordingly, I also rested for the night. On next morning, one of the villagers, namely Sri so-and-so, came to my residence asking for a form. During that time, I have seen so-and-so coming out of his room, opening in the door. He came to me and told me that his wife ran away from his room. I instructed him to search for his wife, as she used to help at my kitchen. So-and-so went away. After some time, one lady of our village came to my residence and told that so-and-so has killed his wife on previous night. Accordingly, I, along with Sangkandu Jesibo, went inside the room of so-and-so, but we could not see anyone inside. When we searched we have seen the wife of so-and-so is under the bedsheet. Her body was wrapped with bedsheet. After that, I got scared and asked so-and-so over the phone to immediately come to my residence. I have inquired him about death of his wife. So-and-so admitted before me that he has killed his wife. I immediately took so-and-so to Balokpung PS and handed over to the police. Now, my lord, one thing to be noted, my lord, he has read out the cross-examination that he has not admitted before police arrived. Now, this fact has to be appreciated. Police never arrived there. They went to the police station, my lord. Thereafter, police came to our residence and recovered the dead body of the wife of so-and-so from his room beneath the bed. I was told that one dowel and one piece of wooden was used for committing the offense. I have seen the bunch of hair belonging to deceased lying near the bed. The dead body was taken to hospital for PME, and so-and-so is detained at police station after his arrest. As per customary ritual, we have performed religious ceremony for purifying our resident after such death. I have asked father of so-and-so for performing ritual, but he denied cooperating me. During the time of recovery of the body, police went inside the room and searched for weapon of offense used for murder. Police has prepared inquest report in my presence and searched the weapon of offense. I have put my signature as witness to inquest and seizure. During the stay at our residence, I have not seen accused quarreling with his wife. PM exhibit, my lord, these photographs and the seizure, everything was approved. Cross, my lord. I have not filed the written FIR in present case, not relevant. I have not seen the incident of murder. There is no question of witnessing the incident. I do not know whether the lady informed me about the murder has seen the incident or not. That was also not seen. I was interrogated by police. At my residence, there is no other tenant. I used to reside alone, and I allot one room to accused for living with his wife. I have not given police statement. Accused has not admitted before me regarding the murder before arrival of police. He doesn't say that he has never admitted. It says before arrival, he has not admitted, meaning thereby it can be read as after arrival of the police, he has admitted, my lord. It can be read in that manner. It doesn't say he has never admitted, my lord. Because what I'm trying to say, my lord, it's an extrajudicial confession, my lord.
But now it's not. After cross, it is not. Before cross, it was extrajudicial.
Yes, my lord. It only says he has admitted. Here again, my lord, they have not totally discarded this statement because it says accused has not admitted before me regarding the murder before arrival, my lord. It can be read as after arrival. And prior to that, he has taken the accused to the police station, my lord. And later on, police arrived, my lord.
Yes.
In between, he has admitted. I was shown the material exhibit at PS during the time obtaining my signature on seizure memo. I have not seen police recovering the seized material from PO. Now, this is interesting, my lord, in the later part. It is not a fact that so-and-so has not committed the murder and he is falsely implicated in the present case. It is a fact that accused has not disclosed the reason or motive of killing his wife. Again, my lord, it corroborates with the earlier one. The motive has not been disclosed, and why he has been killed has not been disclosed. This is the subsequent, my lord, the statement which has been given before the PW3, because it clearly says, my lord, he has not disclosed the motive, but he has admitted he has committed the offense. I have seen the wife of so and so getting drunk for 2-3 occasions before the incident. I do not know where so and so has committed the offense or not. The nature of so and so was good, and I have not heard any wrong incident about so and so. Now, here, my lord, here this is to be noted. I have put my signature in exhibit document as I have seen the same. Now, through cross, they bring it into the record that he has witnessed the seizure of the weapon, my lord. In cross,
Yes.
police has prepared the document, and I am the Gaon Bura of village. I asked to put my signature. I went to PS and put my signature. During the time of arrest of so and so, there was no other witness except me. Now, my lord, from PW3, it can be inferred that the offense was committed prior to 11 o'clock. Because when he came, the room was locked from inside. And after that very next day, he has seen that accused is coming out. And now, my lord, see the conduct, my lord. He coming out and he's lying that my wife is run away from the house. Later on, he himself is admitting, I killed my wife. Now, regarding, my lord, the injury part, I will come later, my lord. And now, the second part is, my lord, prior at the time when they were disputing a quarrel between the this accused and the deceased person, my lord, one person has witness. That is witness number Jam Miji, my lord, page number 29, PW1.
Okay.
Now, the accused defense has stated that he has not assaulted the victim on head, any vital organ of the head, basically. So prior to that, my lord, their defense is she came injured already. Now, from the statement of this PW1, it will be clear that at that time when they were quarreling, she was not sustained any injury. Nothing has been seen on her face, my lord. Mechanically come to PW1 statement, my lord. I am appearing in the case on being summoned. I know the accused so and so is standing on the dock as he is my uncle. Since August 2021, I have been residing at Balakpung with my children. I heard the wife of accused was died, but I do not know whether she was died due to illness or murder. I gave a statement to the police in connection to this case. I heard the death of the wife of the accused in fine morning and previous night. I personally hear that quarreling between the accused wife and the accused husband. I am the neighbor of the accused person, and our house are at the distance of 6 meters. I went to the house of the accused and tender my advice to the accused person to stay calm and return back. The deceased wife was an Adivasi. The accused and the deceased were my new neighbor, and I heard as many as 3 to 4 times quarrel between them. I identified the photo so and so. Now, my lord, the cross. It is a fact that I did not see the assault to the deceased by the accused. It is in fact not their defense, my lord. Meaning thereby, at that point of time, she was not sustained any injury. It clearly says he has not seen the assault. He has not seen the assault. Then why injury, my lord? Only after coming home and in between 11 at night, the incident has happened, my lord. And here, the PW1 says he has not witnessed the assault. PW2, my lord, not relevant because they have not seen even, they were just the guardian. And my lord, PW4 lodged the FIR, even it's a relative, after knowing from the person that she has been killed. So he lodged an FIR and he identified the deceased. And the, my lord, the PW5, the medical one, my lord, before that, my lord, will go to the MLC report, my lord, the post-mortem report, page 26, my lord. My lord, again, your lordship, it's a well settled, my lord. The doctor cannot say whether it was a murder or not. It is the finding of the court, legal finding of the court, basing on the injury. The only thing the doctor can give is the opinion, whether injury is the new injury, what kind of injury it was, and it is the court who will decide whether it was done by or committed by, inflicted by the person or not. That is the court to be decided basing on the fact and circumstances of the case, my lord. Now, my lord, may come to this page 26, second column, external appearance, my lord.
Yes.
One small lacerated wound, 1 centimeter on lower lips, my lord. Now, my lord, we have to understand how lacerated wound normally caused, my lord. It caused by the blunt force impact, my lord. And wood is not a sharp, my lord. In one dow, there is not a cut mark, but, my lord, the blunt one. Now, from this, my lord, it also corroborated with the, my lord, the other partner. So far as the presence of the accused and deceased is concerned, it established, my lord. Now, who committed? See, he has stated in his 164 statement, and my lord, 164 statement cannot be taken as a gospel truth, my lord. It has to be corroborated with as a matter of prudence. However, it is not a law of evidence or rule of evidence. So now here, my lord, lacerated, my lord, this wound is there, which is supposed to be caused by the blunt weapon, my lord, blunt object. And blunt object which was recovered was the wooden and the, my lord, rod. That was recovered from there. And second part is, interestingly, my lord, if the defense saying that his wife was subjected to assault prior to coming to the residence, why he has not taken her to the hospital, my lord? The ordinary course of conduct, that has to be looked into, my lord. Because conduct is also violent. It's recognized by the Section 8 of the Evidence Act, earlier act. Now, so, my lord, the conduct, my lord. And hiding the body of a wife in a bed sheet, my lord. That has been eyewitness. And, my lord, as I have stated, my lord, PW3 has never been shaken, my lord. They try to shake it, but again they bring it into the record by their own cross-examination.
Okay.
And now, my lord, I'm not going into the 164 statement, but 164 statement can be relied in this case for assurance, my lord, that yes, this thing has happened. Although he has admitted that he has assaulted on thigh, that cannot be, in fact, my lord, considered as a truth one. He has hidden something which is established from the circumstances itself, my lord. And, my lord, so far as 302 is concerned, to attract 302, my lord, the injury must be there, the nature of injury, and the intention to inflict the very injury that has been inflicted to the accused. And, my lord, whether that injury is sufficient to cause that in ordinary course of nature or not, my lord. If 4 of these are established, my lord, whether there was no intention to kill the deceased, or whether there was no knowledge, motive, that is immaterial, my lord. It is well settled, my lord. Here in this case, they both are within the 4 wall. In between, when the owner came, PW3 came, after 11 o'clock, there was no any movement, and they don't even take that defense that in between anybody or anyone came there or they went outside. That defense they have never taken, so that the possibility of involvement of other person would come. No, my lord, that defense has never been taken. And the second part, my lord, what they are trying to do is, my lord, they are just trying to convert 302 into 304, my lord.
Yes.
So that part, my lord, for that, my lord, I will rely the judgment. That, my lord, the head injury is there. If suppose in the present case, if there was only injury mark on the thigh, then it can be presumed that there was a intention was not there to cause death also. But, my lord, if medical evidence come and say that because of that injury that person died, that will be sufficient for 302. But here in this case, in a vital organ, my lord, head, there is an injury. And not cut mark, it's a blunt, my lord. That injury, my lord, I have defined it. Lacerated wound will be caused by the blunt force, my lord, impact. And they both were together there. And the defense that she already sustained injury, then again the question comes, if your wife has sustained injury, why you assault her? And why you have not rushed to the hospital? That conduct. Now it will be additional link, my lord. So, and my lord, second part is 313.
I think it's time.
Lunchtime. Yes, you can complete. How long will it take?
My lord, after I will only rely on some authorities, then I will finish. My lord, I may take, my lord, hardly 20 minutes, my lord, more.
Okay, then after that.
Yes, madam.
After recess, we'll
Yes, yes,
we'll be back.
Thank you. May I, Your Lordship?
Yes, yes.
My lord, may kindly come to page 44, the 313, my lord. Of the accused.
313.
313, yes, my lord. This is not a substantial piece of evidence. However, my lord, the same has a corroborative value.
Yes, yes.
So, my lord, let us see, my lord, whether it's corroborate with the testimony of PW13 and the other prosecution witnesses, my lord. My lord, one. Although, my lord, marking is not there, but one is PW1 Srimati so and so. Stated that she has residing at Balokpung with her children since so and so. She heard your wife was died, but she do not know whether she was died due to illness or murder. She gave a statement to the police in connection with to this case on previous nights of death of your wife. She personally heard quarrel between you and deceased wife. What do you say to say? What do you have to say? It is a fact that on 27th there was an argument between me and my wife, and that time she came to console us. Now it's established she came. That means whatever she has witnesses is intact now, my lord. And two, my lord. PW1 stated that she is your neighbor and their house are at the distance of 6 meters. He went to your house and tendered his advice to you to stay calm and return back. The deceased wife was an Adivasi. You and the deceased were her neighbors, and she heard as many as 3 to 4 times quarrel between you and deceased. What do you say to this? It is a fact that she is our neighbor, but before the incident, there was no quarrel between me and my wife. My lord, her presence and when going to the place of occurrence is established. Now, my lord, may kindly come to 8, my lord, that is in page number 3, or 46, my lord, 46.
Okay.
My lord. PW3.
Yes, PW3.
PW3 stated that on the next morning, one of his villagers, namely so and so, Jesibo, came to his residence asking for a form. During that time, he had seen so and so coming out from his room, opening the door. You came to him and told that your wife ran away from your room. He instructed him to search for your wife as she used to help at his kitchen. What do you say? What do you have to say? It is a fact that when I came out from my house, I have seen him and I told him that my wife ran away. I told like that as I was confused, my lord. This is, my lord, even the conscious guilt, my lord. My lord, now 11, my lord. 11, that is the last one, my lord, of the same page, PW3. Last, my lord, last question. PW3 stated that thereafter, police came to their residence and recovered the dead body of your wife from your room beneath the bed. He was told that one dowel and a piece of wood was used for committing the offense. You have seen bunch of hair belong to the deceased lying near the bed. The dead body was taken to hospital for PME and you are detained to police station after your arrest. As per customary ritual, they have performed religious so and so for purifying their resident. After such death, he had asked your father for performing so and so, so and so. Now here, my lord, here in the questionnaire, even the hiding of the body, my lord, and the piece of wood for committing an offense, that has been put before the accused, my lord. And now accused says it is a fact. It's again corroborated, my lord. So, my lord, considering this, my lord, statement also, my lord, the presence and the committing of the offense is clearly established. And the intention only, my lord, the intention that can be called out from the circumstances only, my lord, because there was no any eyewitness. And it can be inferred from the injury, my lord. Even if we take, assuming, my lord, it was directly, they are saying since they have not stated. In this kind of cases, my lord, the offender will never state directly that I have hit her on her head, because he has a defense that he is admitting that he has assaulted.
But my lord, the injury, my lord, sustained by her, that the injury was not the simple one, my lord. That's so, my lord, serious that result in the death of this deceased. And prior to that, my lord, the defense that she has sustained injury prior to the coming back to the house, my lord. For that, there is no any defense to show that she was assaulted by someone or fallen somewhere. It's just a mere statement that will not suffice without any material, my lord. There must be a material to corroborate with such a statement, my lord, and that too substantial one, my lord. And there one more defense is there that she was ill, my lord, sick. That was also not substantiated. I will come to the, my lord, DW 1 and 2 after that, my lord.
That is not required.
Okay, my lord.
Because the PM report says she died of injuries,
Yes, my lord.
not of ailment.
Yes, my lord. Absolutely, my lord. Yes, that defense they have taken, my lord, on their defense, I'm saying, my lord. Otherwise, my lord, the 164 statement, the prosecution has never relied on 164 statement. It was only relied as a matter of assurance, my lord, whether the prosecution was succeed to establish the chain of circumstances or not. Because, my lord, the prosecution has to prove the fact forming chain of circumstances consistent with the guilt of the accused and inconsistent with his innocency, my lord. Here, my lord, within the four wall, within 11 o'clock, my lord, everything incident has happened. The one person has witnessed it prior to the incident, by the time when they were quarreling. They have not witnessed anything, any mark on her face. They have not stated anything, whether she has sustained injury or she was unconscious, anything. They just came and consoled them and they went back. 11 o'clock, PW3 came to the resident and he has found that the door was closed. And the very next day, the conduct, if, my lord, a normal course of conduct, my lord, yes, my lord, if he has not committed, then a prudent person ought to have go and tell directly that last night I have just assaulted on the leg and she succumbed, my lord. But, my lord, see the conduct, my lord. He raped the body, hide inside the bed, and lying to the PW3. Later on only he admitted, and that admission will be considered as an extrajudicial confession, my lord. Because, my lord, PW3 never said that he has never admitted in cross. He says he admitted before court, before police. He has not admitted before court arrived. Meaning thereby, prior to that, he has already been, my lord, admitted. Yes. So now, my lord, nothing much to submit on the DW1 because there's nothing there to in their defense, my lord. Now we rely certain authorities, my lord.
Yes.
And then I will close my argument.
Yes, yes. That entire bunch.
No, my I will not. My lord, we have to come with the most of the judgment. It's cover everything because what will come from that side we never know. So we have to come prepared with all the authorities, most of the authorities. But I will rely the only relevant one, my lord. My lord, here the disclosure statement is there, my lord, the 27, my lord. So I will rely on that, my lord. On disclosure also, my lord. It is reported in the Bijender alias Mandar 2002-1 SCC 92, my lord. इधर दे 2002-1 SCC 92 page. My lord, the paragraph 17, my lord, I'm relying it, my lord, because the 27, the disclosure statement is there, my lord. And they are not challenging the procedure, my lord. They are saying only because the police has stated that he has not properly recorded under 27 of the Evidence Act, my lord. Now, what my humble submission is, my lord, it is the court to decide whether that will suffice or not, my lord. Now, I will rely, my lord, para 16, my lord.
Para 16?
Yes, Your Lord. May I read, my Lord?
Yes.
We have implored ourselves with the abounding pronouncement of this court on this point. It may be true that at time the court can convict an accused exclusively on the basis of his disclosure statement and the result recovery of inculpatory material. However, in order to sustain the guilt of accused, the recovery should be unimpeachable and not be fraught with element of doubt. We may hasten to add that circumstances such as the period of interval between the malfeasance and the disclosure, commonality of the recovered object and its availability in the market, nature of the object and its relevance to the crime, age of transferability of the object, the testimony and the trustworthiness of the attesting witnesses before the court, and or other factor are weighed consideration that aid in gauging the intrinsic evidence value and credibility of the recovery. Now here, my lord, the recovery was not made out of the house, my lord. It was recovered from the inside the room only, my lord. There is no any possibility of planting any weapon by any other person. So if the court find that it's an unimpeachable, my lord, solely on the basis of that also, my lord, the conviction can be upheld, my lord.
Yes, yes.
And my lord, on my lord, extrajudicial confession, my lord, because I'm relying on PW3 as an extrajudicial confession. This was reported on 2003-8 SCC 180. State of Rajasthan versus Rajaram.
Okay.
Yes, my lord. From para 18, my lord. Para 18, 19, and 21.
Para 18, 19, 20.
Yes, my lord. Confession may be divided into two classes, that is judicial and extrajudicial. Judicial confession are those which are made before a magistrate or a court in course of judicial proceeding. Extrajudicial confession are those which are made by a party elsewhere than before a magistrate or court. Extrajudicial confession are generally those that are made by a party to or before a private individual, which includes even a judicial officer in his private capacity. It also includes a magistrate who is not especially empowered to record confession under 164 of the Code of, or a magistrate so empowered but receiving the confession at a stage when Section 164 does not apply. And as to extrajudicial confession, two questions arise: were they made voluntarily, and are they true? As the section enacts, a confession made by an accused person is irrelevant in criminal proceeding if the making of confession appeared to the court to have been caused by any inducement, threat, or promise. Having reference to the charge against the accused person, proceeding from a person in authority and sufficient in the opinion of the court to give accused person ground which would appear to him reasonable for supposing that by making it he would gain any advantage or avoid any evil or temporal nature in reference to the proceeding against him. It follows that a confession would be voluntary if it is made by accused in a fit state of mind, and if it is not caused by inducement, threat, or promise, which has reference to the charge against him. Proceeding from a person in authority, it would not be involuntary if the inducement does not have A, does not have reference to the charge against the accused person, or B, it does not proceed from a person in authority, or C, it is not sufficient in the opinion of the court to give accused person ground which would appear to him reasonable for supposing that by making it he would gain any advantage or avoid any evil or of a temporal nature in reference to the proceeding against him. Whether or not the confession has voluntarily would depend upon the fact and circumstances of each case. Judged in light of the Section 24, the law is clear that a confession cannot be used against the accused person unless the court is satisfied that it was voluntarily, and at this stage the question whether it is true or false does not arise. If the fact and circumstances surrounding the making of a confession appear to cast doubt upon the veracity or voluntariness of the confession, the court may refuse to act upon the confession. Even if it is admissible in evidence, one important question in regard to which the court has to be satisfied with is whether when the accused made the confession, he was free man or his movement were controlled by the police either by themselves or through some other agency employed by them for the purpose of securing such confession. The question whether a confession is voluntary or not is always question of fact. All the factor and all the circumstances of the case, including the importance factor of the time given for reflection, scope of the accused getting a feeling of threat, inducement or promise must be considered before deciding whether the court is satisfied that its opinion is impression caused by the inducement, threat or promise. If any has been fully removed, a free and voluntary confession is deserving of the highest credit. A free is presumed to flow from the highest sense of guilt. It is not to be conceived that a man would be induced to make a free and voluntary confession of guilt, so contrary to the feelings and principle of human nature. If the fact confessions were not true, deliberate and voluntary confession of guilt, if clearly proved, are among the most effectual proof of law. An involuntary confession is one which is not the result of the free will of the maker of it. So where the statement is made as a result of harassment and continuous interrogation for several hours after the person is treated as an offender and accused, such statement must be regarded as involuntary. The inducement may take the form of promise or a threat, and often the inducement involve both promise and threat. A promise of forgiveness if disclosed is made, and threat of prosecution if it is not. A promise is always attached to the confession alternative, while a threat is always attached to the silence alternative. Thus, in one case, the prisoner is measuring the net advantage of the promise minus the general undesirability of a false confession as the against the present unsatisfactory situation. While, in the other hand, he is measuring the net advantage of the present satisfactory situation minus the general undesirability of the confess against the threatened harm. It must be borne in mind that every inducement, threat, or promise does not vitiate a confession, since the object of rule is to exclude only those confessions which are testimonially untrustworthy, and the inducement, threat, or the promise must such as the calculate to lead an untrue confession. On the aforesaid analysis, the court is of the determining the absence or presence of an inducement, promise, etc., or is sufficiently, and how or what measure is work on the mind of the accused. If the inducement, promise, or threat is sufficient in the opinion of the court to give the accused person ground which would appear to him reasonable, for suppose that by making it he would gain by advantage or avoid any evil, it is enough to exclude the confession. The word appear to him in last part of this section refer to the mentality of the accused. 19. An extrajudicial confession, if voluntary and true and made in fit state of mind, can be relied upon by the court. The confession will have to be proved like any other fact. The value of the evidence as to confession, like any other evidence, depend upon the veracity of the witness to whom it has been made. The value of the evidence as to confession depend on the reliability of the witness who gives the evidence. It is not open to any court to start with a presumption that extrajudicial confession is weak type of evidence. It would depend on the nature of circumstances, the time when confession was made, and the credibility of the witness who speak to such confession. Such a confession can be relied upon and conviction can be founded thereon if the evidence about the confession come from the mouth of witness who appear to be unbiased, not even remotely inimical to the accused, and in respect of whom nothing is brought out which may tend to indicate that he may have a motive of attributing an untruthful statement to the accused. The words spoken to by the witness are clear, unambiguous, and unmistakably convey that the accused is the perpetrator of the crime, and nothing is omitted by the witness which may mitigate against it. After subjecting the evidence of the witness to the Riger test of touchstone of credibility, the extrajudicial confession can be accepted and can be the basis of the conviction if it is passes the test of credibility. So now, my lord, the 164 statement, he has statement given by the accused. That procedure, there is no any procedural lapses, and the second part is extrajudicial confession. In fact, my lord, if we see both the statement, it's trustworthy, my lord. The fact has been properly narrated. And even he has come across the rigor of the cross-examination done by the defense, my lord. So the state testimony given by the PW3 is sufficient enough, and it can be considered as a credible one, my lord, to act upon it, my lord.
On, my lord, now on conduct, my lord, judgment on conduct, and then on the 302. My lord. Uh, 2013-7 HCC 45, man. Harivadan Babubhai Patel, man. Here, the Honorable FX Court has, my lord, discussed the doctrine of confirmation by subsequent event, my lord, under Section 8 of the Evidence Act, my lord. And here, my lord, it has been further held by the Supreme Court that even the statement of disclosure goes, my lord, held to be inadmissible. It can be taken as taken into consideration for previous and past conduct of the accused, post conduct of the accused, which is relevant under Evidence Act, my lord. Para 16, my lord, 16 to 20 is the relevant one. I read, my lord.
Yes.
Para 16, my lord.
Yes, yes.
The next limb of attack relates to the confession made by the accused person and the issue of leading of discovery of an article. It is submitted that the confession part is absolutely inadmissible, and that apart, when the punch witness has not supported the punchnama, the recovery or discovery of the seized article cannot be utilized against the appellant. There can be no shadow of doubt that the confession part is inadmissible in evidence. It is also not in dispute that the punch witnesses have turned hostile, but the fact remains that the place from where the dead body of the deceased and the other item were recovered was within the special knowledge of the appellant. Para 17. In this context, we may usefully refer to A.N. Venkatesh versus State of Karnataka, wherein it has been ruled that by virtue of Section 8 of the Evidence Act, the conduct of the accused person is relevant. If such conduct influence or is influenced by any fact in issue or relevant fact, the evidence of the circumstances simpliciter that accused pointed out to the police officer the place where the dead body of the kidnapped boy was found would be admissible as conduct under Section 8, irrespective of the fact whether the statement made by the accused contemporaneously with or antecedent to such conduct fall within the purview of Section 27. In the said decision, reliance was placed on the principle laid down in Prakash Chand versus State Delhi Administration. It is worth noting that in a said case, there was material on record that the accused has taken the investigation officer to the spot and pointed out the place where dead body was buried. And this court treated the same as admissible piece of evidence under Section 8 as the conduct of the accused. 18. In State of Maharashtra versus Damu, it has been held as follows. It is now well settled that recovery of an object is not discovery of a fact as evinced in Section 27 of Evidence Act. The decision of Privy Council in Pulukuri Kotaya versus King Emperor is the most quoted authority for supporting the interpretation that the fact discovered evinced in Section embarrass the place from which the object was produced. The knowledge of the accused as to it, but the information given must relate distinctly to that effect. The same principle has been laid down in state of so-and-so, state of so-and-so, so-and-so. In the case at hand, the factum of information related to the discovery of the dead body and other article, and the said information was within the special knowledge of the present appellant. Hence, the doctrine of confirmation by subsequent event is attracted, and therefore, we have no hesitation in hold that the recovery or discovery in the case at hand is relevant fact or material which can be relied upon and has been correctly relied upon. Here, my lord, the subsequent event, this case will be clearly attracted, man. Now, on my lord, 302, my lord.
Not required, I think.
302, my lord. Okay.
Not required.
Okay, not required, my lord. Then, my lord.
302 or 304 part 1.
Yes, my lord. 302.
Not required, I think.
Okay, ma'am.
You want to prove that it is 302
Yes, my lord.
without motive and motive.
Without motive and all, my lord, it's well settled. I think it's not required.
You just give the
Okay, citation.
citation.
Yes, ma'am. And that is AIR 1958 SC 465. Here, my lord, the poor element to attract 302 has been discussed by the FX court. The parts is, my lord, the presence of injury that will be based on objective fact, nature of injury, what kind,
where, how deep, that will be based on objective of the investigation. Intention to inflict very injury, that will be subjective but limited to intention to cause that particular injury. And fourth is, my lord, sufficiency of injury to cause death in an ordinary course of nature. That will be objective on medical inference, my lord. Now, all are, my lord, clearly established in this case. And if above of the four elements, if the four elements are proved, my lord, then
Which paragraph?
my lord, paragraph 12 and 13, my lord.
All right.
Paragraph 12 and 13. Yes, my lord. And my lord, the other aspect regarding FSL, my lord, I don't think need to rely any judgment because it's a well settled that if FSL is not a substantial piece, it has a corroborative value. And even if, my lord, the weapon is not recovered in a case, there are so many cases, it will all depend on fact and circumstances of each case. There are cases where, my lord, even the weapon of offense was not recovered. But basing on the circumstantial evidence, my lord, if court found that there are sufficient evidence.
You can just send across any judgment if you have.
Yes, my lord, I will provide the copy, my lord. I've just taken out, this judgment is, my lord, 2002-7.
FSL.
Yes, my lord, FSL, my lord, here, my lord, if non-recover, even if the weapon is not recovered, even in that case, his conviction can be done, then why FSL will be required, my lord? If circumstances are against the accused. That is 2002-7 SCC 198, my lord. Para 16. And it's a small paragraph. I will just read out, my lord. I will furnish the copy, my lord.
Party's name?
Yes. My lord, the name is Lakshmi and others versus State of UP.
Okay.
Yes, madam, I will read out the para 16. Undoubtedly, the identification of the body, cause of death, and recovery of weapon with which the injury may have been inflicted on the deceased are some of the important factors to be established by the prosecution in an ordinary given case to bring home the charge of the offense under section 302 of the IPC. This, however, is not an inflexible rule. It cannot be held as a general and broad proposition of law that where these aspects are not established, it would be fatal to the case of prosecution. And in all cases and eventualities, it ought to result in acquittal to those who may be charged with an offense of murder. It would depend on the fact and circumstances of each case. A charge of murder may stand established against an accused, even in absence of identification of body and cause of death, my lord. Here, my lord, even in absence of weapon, conviction can be upheld. Then FSL is just a matter of the corroborative piece of evidence, madam. Now, my lord, with this, my lord, the prosecution has, in fact, proved the chain of circumstances beyond reasonable doubt, my lord. And it is only the accused who has committed the offense. There is no any possibility of any other person to come into the picture, my lord. It is him only who has committed the offense, and he has been rightly convicted, my lord, in for 302. So therefore, my humble prayer would be, my lord, this appeal may be, my lord, dismissed, my lord. Obliged, my lord.
Yes, anything else?
Nothing.
Heard, Mr. Your name?
J. Ginny, Lordship.
J. Ginny, learned counsel for the appellant, and Mr. T. Ate, learned additional PP. Reserved for judgment and order.
Yes.
I will be him unlock it us. DB is over?
No, one more matter.
One more matter.
Yes. Item number 8.
May I please, Lord? I am Podi, Lord. Appeal.
Where is item number?
This is MZL appeal.
Next page is there.
Okay. Criminal appeal.
Yes, MZL appeal. Here, my lord, appellant is convicted under 302/201 IPC and sentenced for life imprisonment in this case. So, my lord, first of all, here in this case, the learned district and session judge has based on the conviction is recorded based on the, my lord, confessional statement. Whereas confessional statement is not before the magistrate. This confessional statement of the appellant was made before the villagers only.
Yes.
Therefore, on that basis, my lord, I will make a short submission only here.
Alright.
Short argument only, my lord.
Good. enough.
FIR was filed on 24/9/2020, my lord. Here, that is page 1 of the paper book, my lord. May I read the FIR? FIR regarding mother of Mr. So-and-so, son of so-and-so, village Lavrang. It is very heartening to inform you that this is Mr. Pem Sange, son of so-and-so, village Lambrang, was found missing from yesterday morning, that is 23/9/2020. At the same time, the villagers started searching. Finally, when the villagers reached his home, it was found locked from outside. At the meantime, some villagers went to the window and saw that he was hanging inside the room. Immediately, we have informed to the police personnel, and we all villagers along with the police unlocked the key. But when we saw the body, it was not a suicide. He was brutally murdered using and firewood of some unknown person. This is the FIR. On receipt before the Dirang police station, my lord, on receipt of this Dirang PS case number 15/20 under 302 and 201 was registered, and one SI Tingle was endorsed for investigation. My lord, investigation was conducted and charge sheet was filed.
Okay.
And the charge was spread. My lord, here in the course of trial, the disclosure statement of the appellant accused and the recovery of the weapon of offense was mainly used and referred for writing and conviction against the accused, my lord. So, first of all, may I take your lordship to page 9. Page 9 is the disclosure statement recorded under 162 clause 2 of CRPC, my lord. May I read the content, my lord? This is the disclosure statement of the appellant accused. I, Sri Dorji Singh, as about 21 years, son of so-and-so, village Lobrang, PS Dirang, do hereby disclose that I stay in the village Lobrang and used to look after the cattle of the other villagers. On being employed only paid. In the grazing ground near the village, I have the habit of drinking liquor. I was alleged for maiming and some assault of the villagers earlier, but the issue were settled in the village level. I, in fact, have a very bad habit, as I used to lose my temper very often, even without any provocation. The deceased Pem Sange was known to me. He also used to look after the cattle of the other villagers. I actually do not have any enmity or dispute with him. But since he was staying alone, these days I sometimes used to go to him for drink when I feel thirst for drinks. On the late evening of 22/9/2020, I went to the room of Pem Sangye and demanded some liquor. But Pem Sangye in turn refused to serve liquor to me, saying that his stock has been exhausted. After repeated approach, when Pem Sangye did not serve the drinks to me, I got annoyed and very angry. Very angry. In order to teach a lesson to him, I lifted an axe found in the room and struck Pem Sangye by the axe several times on his face and head. Pem Sangye fell down on floor in the pool of blood oozing out from the injuries. I realized that his circum. Thereafter, to deceive the people, I hanged Pem Sangye by a rope to fabricate the SOC. This is a scheme of crime, Lord. I further disclosed that the axe and the rope both belongs to the deceased, Pem Sangye, and I found them in his room itself. After that, I concealed the said axe in the room below a rack-like structure and locked the room by the lock of Pem Sangye, throwing the case in the nearby bushes to deceive the villagers and to make them understand that the deceased Pem Sangye has gone to somewhere, and also to restrict the villagers from free entry in his room. Since the facts come to light of everyone, I feel there is no point in hiding anything. So I, in front of the witnesses, voluntarily agreed to lead and show the police the place where I concealed the axe. This is the, my lord, disclosure statement of the appellant accused. Then, my lord, another vital evidence against the accused is recovery memo recorded under proceeding under section 27 of evidence statement. Here, may I read this is, my lord, paper exhibit 3, page 10 of paper book.
Yes, yes.
Here, may I read?
Yes.
Whereas the Dorji Siri, age 21, so and so, village Lubrang, POPS police Dirang, and the below noted witnesses that he has committed the offense of murder of one Pem Sangye, son of Sri Donduk of village Lubrang, POPS Dirang, West Kameng district. And whereas the suspect Dorji Sri 21, son of Soe, village Lubrang, Dirang, has voluntarily agreed in front of below noted witnesses to lead the police and show the place where the axe, the weapon of offense by which he has caused the injuries to the victim, was placed, concealed by him. So he is now allowed to proceed from the approaching foot track of the village to the place of concealment of weapons of offense. The suspect Dorji Siring, age 21, son of Dorji Kandu village, Lubrang, POPS Dirang, proceeded towards the southwest direction of the Lubrang village, followed by the police and the witnesses, and after covering a distance of about 25 meters, the whole team reached at the SOC room where the dead body of the victim was found. The place of experience of crime is a dwelling house of the Sri Donduk, the father of the victim. A bed for sleeping a wooden chair are found in the middle of the room. Both seems to be disturbed and not in order. A
It's okay,
small-
we've read it. I've read it.
Okay,
Hmm.
this is the
Hmm.
disclosure statement, and on the leading of the appellant accused, the one iron X having served it as the little portion of the X is unbroken but seized. Yes. As an amicus, Miller. Seized and with handle was seized, Miller. Then this is the only the evidence against this
Yes.
appellant accused. Now, my lord, after charge sheet, was filed before the landed court. The charges was framed against accused under 302 and 201 IPC. And during the course of trial, my lord, all total 10 prosecution witness was examined. No defense was entered in the course of trial. My lord, here, as per the court, my lord, the conviction is based on only made an extra confession before the villagers by the appellant accused, and that is one part. Second argument is that, my lord, the weapons of offense, the X, which has been said to be used or crime was not found any human skins or blood. That is the FSL report, my lord. And that's all. And there is, in the course of trial, my lord, no motive was established, and there was no any single eyewitnesses in the case. And the everything, anything has been, conviction has been recorded on the circumstantial evidence. So, my lord, why I'm submitting this, my lord, incident took place on 22 September 2020. And then villagers of the Lubrang village started searching to both the accused and the victim on 23 September 2020. Then, my lord, this present FIR was filed on 24/9/2020. And it is the evidence of the prosecution witnesses that before filing of the FIR before the police station, on the evening of 23 September 2020, the appellant accused was found in one hut where the sheep and goats are rearing. He's the one of the level. So before arrival of the police, villagers, they have come down to the house of the appellant accused and caught and hold him on that accused and brought the accused to the present place of occurrence. And where before the police, before the villagers, this appellant have confessed. He was tried to deny, but then he was ultimately he was confessed. He have committed the crime. That is the evidence of all the prosecution witness.
Okay.
So, my lord, here may I take some 1 to 2 all the positions are same, my lord. One main is, may I take your lordship to page 52. 46 is the also a deposition. It is the brother of the deceased, my lord. Let us take 46, page 46, PW1. Dorji Wangdi. I am appearing as witnesses in the present case as witness. My deceased brother, late Pem Sange, was killed by the accused in 2020. I provoked the death and the months of incident. The villagers informed me that the house of the deceased was locked from outside, and on noticing from the window, my brother was found hanging by a rope on the ceiling. Accordingly, I personally went to PO and found my brother was hanging by rope on the ceiling, which I noticed from the window. I informed the incident in the evening to the police without pull down the deceased's dead body. And on next morning, the police come at PO. I was present at the PO on the arrival of the police, and the lock was broken. The body was pulled down by the police in my presence. I have checked the body of the deceased and found injuries on the head and right leg. There was also blood on the head and chain. On seeing the sustained injury of the sharp object, I also noticed one X nearby the body of the deceased having blood stain on it, which might be weapon of the offense. During the recovery of the incident, all the villagers were present except the accused had absent from the village. As such, we started casting doubt against the accused. The accused left for upper side of the Lobrang area where sheep or yaks are rearing. We followed the accused in the evening and found sleeping in him in the hut belongs to one of our brother-in-law. The accused on our inquiry admitted to commit the offense of killing the deceased. On further inquiry about the reason of the incident, he disclosed that the deceased was refusing to consume alcohol offered by the accused, and out of anger, he killed the deceased by a wooden stick. Later on, he also confessed to his.
All right.
This is the evidence of PW1, that PW2 all is said that there is a small contradiction, that PW1 says that he have given an alcohol to drink to the deceased, but he denied to drink the alcohol. But PW2 says that he have demanded alcohol from the deceased, but he was not providing. That is why in the disclosure statement also, appellant says that I have demanded alcohol, but then stock was exhausted. That is why I was not given alcohol. On that anger, I killed the deceased. That is the contradiction, my lords. Simple contradiction. My lord, PW2, I am appearing. I was with the accused and the deceased prior to the murder of the deceased by accused. Actually, I was with the deceased along with Dor Pasang in the house of the Dor Pasang. In the meantime, the accused come and joined with us at the house of Dor Pasang. While we were consuming ara, local liquor, I, along with the deceased and the accused, left the house of Dor Pasang and reached to the house of deceased at around 8 p.m. The accused and the deceased had a quarrel and scuffle each other for reasons that the accused, without the permission of the deceased, charged Mock to have a drink water. The deceased made a remark against the accused that such act is amount to commission of theft. I prevented the accused and took him to my house. On the way, the accused purchased more local liquor and come to my house. I asked him to stay in my house, but he left. That
we've read it.
This is all, my lord, the same statement. And then Lordship, may please to come in page 52. Here where the accused has been alleged to be shot confess before the villagers. This is PW4, Sri Prem Tasi. Honor. I am appearing as a witness in murder case of Prem Sanghe. During the month of September 2020 at around 7 p.m., I got the information of the incident, but due to lack of time, I could not go back to village in the evening, as I am living in Rama camp. On next morning, I come to village before arrival of the police and personally interrogated the accused. During my interrogation with the accused, he admitted to commit the offense as the deceased was refused to have alcohol with him. Later on, the police come and broke the lock of the house where I was also present. On opening the door, we found the deceased's body was hanging. This is the statement below. So there is no confession, my lord, before the concerned magistrate under 164 CRPC. This confession, said confession recorded by the Lanet Trial Court is only confession made before the villagers. And that is not a confession. Confession made before the police, extrajudicial confession made before the villagers is not confession. That is my argument, my lord. Then, my lord, as per the appeal, jail appeal of the accused appellant is that, my lord, in page 129, para 4, the appellant stated that, my lord, the appellant begs to state that suddenly he was dressed out the hut where he was sleeping and was coerced by few villagers to admit the guilt for killing his best friend. In fact, the victim was one of his very good friend. In this appeal, my lord, this is 129 page,
Yes.
paper book, my lord.
I'm going
Paragraph
to
4.
29.
This is memo of jail appeal, my lord.
Oh, memo papi.
Memo of appeal. Then, para 5, here memo of appeal says that the appellant also submitted that he could not have possibly virtually killed and hang his childhood beloved friend just for the sake of refusal to consume alcohol, and that they never had any previous enmity. Moreover, the motive of the offense cannot be made out, my lord. So, my lord, on perusal of the impugned judgment and order, where the life sentence has been given to appellant, here only all evidence is based on the extrajudicial confession which has been made before the villagers, and all witnesses present, prosecution witnesses present, has deposed in court that before us the accused has admitted the commission of the crime and recorded life imprisonment.
Okay.
So this is my only my limited submission. That's all.
Yes.
Already the brief has been submitted by senior counsel. I would just like to refer on only few statement of witnesses and few particular evidences that were taken while passing the judgment. If I may take your lordship to the FIR again, it is at page number 1.
Yes.
If I may read you. It is very disheartening to inform you that this is Mr. Pema Sanghe, son of so-and-so. Village was found missing from yesterday morning, 23/9/2020. At the same time, all the villagers started searching. Finally, when the villagers reached his home, it was found locked from outside. At the meantime, some villagers went to the window and saw that he was hanging hanging inside the room. Now I would like to point out that first of all, the room was locked from the outside, and the deceased was found hanging from hanging inside the room. Now at this point of time, none of the villagers had not broken the lock of the door to get inside, and then informed the police, who later on came and broke the lock of the house. Now, if I may take your lordship then to page number 9, which I already read, but I would like to point out some relevant portion. Your lordship. Page number 9 is the disclosure statement. Your lordship.
Yes.
If I may read the second paragraph. Your lordship.
Yes.
On the late evening of 2020, I went to the room of Prem Sanghi and demanded some liquor, but Prem Sanghi in turn refused to serve liquor to me, saying that his stock has been exhausted. After repeated approach, when Prem Sanghi did not serve the drink to me, I got annoyed and very angry. In order to teach a lesson to me, I lifted an axe found in the room and struck Prem Sanghi by the axe several times on his face and head. Prem Sanghi fell on the floor in the pool of blood oozing out from the injuries. I realized that he succumbed. Thereafter, to deceive the people, I hanged Prem Sanghi by rope to fabricate the SOC. I further disclosed that the axe and the rope both belonged to the deceased Prem Sanghi, and I found them in his room. After that, I concealed the said axe in room below a rake-like structure and locked the room by the lock of Prem Sanghi, throwing the keys in the nearby bush to deceive the villagers and to make them sustain that the deceased Prem Sanghi has gone to somewhere, and also to restrict the villagers from free entry in his room. Now, this was a disclosure statement. Subsequent to his disclosure, under 27 of Evidence Act, the X was found, which the lordship will find at page number 10.
Yes.
The lordship will see on his pointing out the X, which according to his disclosure statement was in the same place that he has placed the lordship. An X was found, and X connected to the then handle. 2 of the items were found.
Yes.
Now, if I may take your lordship to the inquest report, which is at page number 18. The inquest was conducted on the day of the FIR, your lordship. If I may take your lordship to point number 9.
Yes.
Roman 1, your lordship will see other information, if any. Lordships have found.
Yes, yes.
Both sides of ear seen some multiple injuries, and on chin some multiple injuries found. 10 is opinion of eye about the case of the death. It is suspected that the death of the deceased in inflicting seen sharp weapon and large strangulation on neck by rope. The lordship will point out that there were injuries, multiple injuries in his ear as well as on chin, your lordship. Now, to substantiate that, your lordship will then come to page number 33, which is the post-mortem report.
Yes.
Page number 33. If I may take your lordship to the second column, which speaks about the external appearance, your lordship. Column number 2, your lordship will find wound, position, size, and characters. Lordships have come.
Yes, yes.
Laceration behind ear, so and so, injury ear 1/3 upper ear mining, laceration in the chin, laceration lower lips, laceration near occipital region, side approach. Lordship will see at column 4. Ligation mark seen running from mandibular angle to behind right ears round the neck.
Yes.
Then your lordship will come to page number 34. Column 4, table 4 reflects the muscle bone joints. You will see broken maxilla and mandible seen. Then the final is the observation, your lordship. Detailed description of injury is multiple lacerated wounds seen over chin, lower legs, right ear, and near occipital region, broken maxilla and mandibular bones seen. Also, ligation marks seen running from below right mandibular angle to behind right ear, running all around the neck. This was the medical post-mortem report, your lordship. Now, if I may take your lordship to the FSL report, the seizure of the clot of the, if I may, I deeply apologize, your lordship. If I may take, prior to the, if I may take your lordship to the seizure of the clot of the accused, which your lordship will find at page number 12. Okay. Page number 12, your lordship will see Caesar. This is the Caesar made from the accused, your lordship. Lordship will see description of Caesar is one synthetic jacket black in color with other print on it. Second is one paper jeans paint black in color. And the third is plastic wooden combined rope with two knots. So these seized materials were sent for the FSL. Your lordship will find the FSL report at page number 41.
Okay.
Page number 2 is the relevant portion that I would like to refer to, your lordship.
Page 41, page 2.
42. 42 is the relevant.
42, okay.
Lordship will find exhibit A is the blood sample, one sealed packet, paper packet containing one gauze piece having reddish brown stain. Exhibit B is the jacket, one sealed cloth parcel containing one multicolored jacket. Exhibit C is the pant of the accused. Exhibit D is the X. Now your lordship will find the result examination. The second paragraph is, on the basis of the above examination, it is concluded that human blood could be detected in exhibit A, B, C, D. That means all of the seized items which were sent for the FSL, in all of them the human blood was detected. 2 is ABO blood group could not be detected in exhibit A, B, C, and D, which may be due to degradation and or minute amount of biological material. So only all of the seized articles contain human blood, except the examination could not prove that what kind of blood group was it, because of the reason due to delay in sending the FSL seized items for the FSL. Now, if I may take your lordship to the statements of only 2 witnesses, I'll be making a more specific summation on the statement of the 2 witnesses, your lordship. First, your lordship will come to page number 46, your lordship.
Yes. Page 46, yes.
46, I would read from paragraph 2, your lordship. Second paragraph. I have checked the body of the deceased and found injury on head and right leg. There was also blood on the head and chin. On chin, deceased sustained injury of sharp object. Also notice one X nearby the body of the deceased having blood on it, which might be the weapon of the offense. During the recovery of the incident, all the villagers were present except the accused was absent from the village. As such, we started casting doubt against the accused. The accused left for upper side of the Lubrang area where sheep or yak are rearing. We found the accused in the evening and found sleeping in hut belongs to one of our brother-in-law. The accused on our inquiry admitted to commit the offense of the killing of the deceased. On further inquiry about the reason of the incident, he disclosed that the deceased was refusing to consume alcohol offered by accused, and out of anger he killed the deceased by a wooden stick. Later on, he also confessed to hit the deceased by axe. During such confession, many villagers were present, out of which I remember are so and so, so and so. In the meantime, police also arrived at Lubrang and we came back with accused, and the police at PO exhibit so and so is he's a witness to all the recoveries as well as the Caesar, your lordship. Second paragraph, your lordship. Second page, your lordship. Deceased body was conducted PME. Later on, the body was handed over to us. I know the accused since childhood. The accused became mad after having alcohol. His prose says, I had seen the accused committing the offense, but he was seen together with the deceased in the evening. The accused, deceased, and Mr. Lopa were together in the evening of the incident consuming alcohol, which I have personally seen. I forgot the exact time, date, and month of the incident. Mr. Lopa and accused left PO my house in the evening. As per the disclosure of the accused, he came back again to my house and asked to have more drinks, to which the deceased refused. An incident took place. It is true that no one has seen the accused coming back to PO. PO and Upper Lubrang is around 1 kilometer. House of Lopa and PO is around 100 meters distance. It is not possible to hear the sound from other house. Accused is so and so. So this was in the prose. He has stated that it's not exactly a last scene theory, but then prior to incident, he has seen 3 of his brother and accused as well as one of the witnesses. They were together and having a drink. Now this third witnesses, second witnesses whose reference was made by PW1, you also will find at page number 48. He is the prime witness to this incident. This is on his statement in corroboration to many of the circumstances which has led to the commission of the crime and leading to the murder of the accused. Your Lordship, if I may start from the very first paragraph, Your Lordship. I'm appearing as a witness in the present case as witness. I was with the accused and the deceased prior to the murder of the deceased by the accused. Actually, I was with the deceased along with Dor Pasang in the house of Dor Pasang. In the meantime, the accused came and joined with us at the house of Dor Pasang while we were consuming arak. I, along with deceased and the accused, left the house of Dor Pasang and reached to the house of the deceased at around 8 p.m. The accused and the deceased had quarreled and scuffled each other for reason that the accused, without permission of the deceased, started muck to have drink water. The deceased made a remark against the accused that such act is amount to commission of theft. I prevented the accused and took him to my house. On the way, the accused purchased more liquor and came to my house. I asked him to stay in my house, but he left my house with purchased alcohol. In the village on the next day, I got information that the accused did not join on duty to take out the milk of the yak, and also the deceased is missing as the house is found locked from the outside. On inquiry, I narrated all this story happened in previous night. All of us started searching both the deceased and accused. On my visiting to the house of the deceased, I noticed the local liquor which was purchased by the accused in previous night nearby the gate of the deceased. On revealing such discovery, we started doubting that something was wrong in the case of missing. The window was not locked. 3 p.m. Shring had looked inside the house through window and found the body of the deceased in hanging position. Sri Nawang Norbu also seen the body of the deceased from the window, and accordingly, it was informed to the police. The house was not open until arrival of the police. The police arrived on the next day of the incident. The house was opened in my presence, and we found the axe and stick also. In the night, some owner of the yak interrogated the accused when he was found in a hut where yaks and cows are rearing in Lubrang, during which he admitted to commit the offense. The reason of the offense was disclosed. The deceased refused to consume more alcohol. The accused also confessed the guilt in my presence on the arrival of the police at the village. On his admission, police arrested him. I have narrated the discovery of the alcohol bottle near the house of the deceased to the police. The axe was found near to the dead body of the deceased. So. In his throat, he states, it is not that I have not seen the accused going to the house of the deceased. It is not a fact that I have not narrated about the discovery of the alcohol bottle near the house, the deceased, which was purchased by the accused in previous night on the way. It is not a fact that the bottle is not produced in the court. The bottle was not recovered as I was examined after 2 or 3 days passed from the incident. The police might not seize the bottle. I forgot the time when the accused left my house. I have not seen the incident. It is not a fact that I am not implicating false statement against the accused. I cannot say about the commission of the offense by the accused, but I believe that he committed the offense as he admitted to commit the offense. I do not have any written documents on this admission. There was no enmity between the accused and the deceased, but in the evening, there was small quarrel and scuffle. So he is a prime witness who stated that prior to the incident, after having a drink with certain other friend, he and these witnesses went to the deceased house, Your Lordship.
Okay.
Now, if I may take Your Lordship I won't read the entire part, but if I may take Your Lordship to this is PW3, Your Lordship. PW also states that the accused has confessed before him as well as before other villagers. PW4 is also a Caesar witness to the jacket and the jeans of the accused, and he is also a witness to the confession made before the villagers. PW5 is also the one who has witnessed the confession statement before the villagers. Your Lordship. PW6, Your Lordship will see. I'll just point out this small line from PW6, Your Lordship. If Your Lordship will see the cross made to him, Your Lordship, at page number 54, PW6, I did not witness the incident of the commission of the offense. It is not a fact that the accused did not admit to commit the offense before me. The accused used to stay in Chongri Ghat cow shed within 1 kilometer away from village. It is not a fact that the accused was beaten by the police and villagers. It is not a fact that this is committed suicide. No magistrate was present at the time of breaking up. It is not a fact that blood stain in the jacket. Now he states in his cross that there was no pressure from police, neither from the village, while the accused was beaten in any form to make his confession. Now, if PW7 is also one who has been witness to such extrajudicial confession.
Yes.
PW7 is the IO, Your Lordship. PW9 is the MO. Doctor who has conducted the PME, Your Lordship. Now, if I may take Your Lordship to page number 61, which is the 313 of the accused. There, the accused were
Yes.
what you will see it. Pages are actually there were 10 questions put up to the accused, Your Lordship. There were 10 questions put up to the accused, Your Lordship. In none of the questions put up by the court under 313, he made any, he has given any explanation to or any of the question. His only answer to all of the questions was that we have nothing to say about the incident. Now, if I may, while summing up my summation, would state that the entire judgment was more particularly based on extrajudicial confession, Your Lordship, the circumstantial evidence, Your Lordship, and the recovery made by the accused and his confessional disclosure statement under 162, as well as recovery of the weapon under 27 of the Evidence Act. Your Lordship will see FIR clearly reflects, and all the statement, including that of the IO, reflects that the door was closed from the outside. If such submissions is being made that he has committed suicide, Your Lordship, in any form, any person living alone while committing suicide would not lock himself from the outside. It would not, to much extent, would be locked from the inside, Your Lordship. There is, to the entire incident, Your Lordship, only on the presence of the police, the lock of the door was open, and then all the villagers got inside the place of occurrence where he was hanging, Your Lordship. So there is no case of manipulation done by any of the persons, Your Lordship. Now, the confession made by the accused and subsequent recovery clearly states that, and the statement of the PW2 would clearly state that on that particular night they were having a drink with certain people. Subsequently, they went to the house of the deceased, Your Lordship. And in his disclosure, the motive of such murder, the reason that such murder took was explained, Your Lordship. Subsequently, the FSL report also clearly states that whatever apparel he was wearing, which was seized subsequently, contents of the human blood, Your Lordship. Now, even that question was put up before the accused, but he could not explain to what extent the blood was from, Your Lordship. Now, also the statement of the PW2 that the liquor bottle which he had purchased on the previous night, and when he went to the place of occurrence before the lock was broken, he saw the that same liquor bottle was outside of the house of the deceased. Now, anything apart from that, none of them are eyewitness to such this case, Your Lordship. If I may then place, Your Lordship, that because the case is much more of disclosure, extra judicial confession, and the FSL report, Your Lordship. With regard to disclosure, if I may take, if I may commit a citation, Your Lordship, of the apex court. This is of Yedala Subha Rao and another versus the Union of India. If I may take, Your Lordship, to paragraph 13 and 14.
Yes.
Down below, Your Lordship will see the page number. Page number is at page 4, paragraph 13.
Yes.
If I may read. Now we'll have to decide whether the disclosure statement dated so and so is admissible in evidence. It is necessary to advert to the law laid down by bench of 3 honorable judges of this court in the case of Jafar Hussain Dastagir versus State of Maharashtra. This court followed the decision of the Privy Council in the case of so and so, which is locus clausus In paragraph 5 of the decision in the case of Jaffer, this court held that under section 25 of the Evidence Act, no confession made by an accused to police officer can be admitted in evidence against. An exception to this is, however, provided by section 26, which make a confessional statement made before a magistrate admissible in evidence against an accused, notwithstanding the fact that he was in the custody of the police when he made the incriminating statement. Section 27 is the provision to section 26 and make admissible so much of the statement of the accused which leads to the discovery of a fact deposed to by him and connected with the crime, irrespective of the questions whether it is a confessional or otherwise. The essential ingredients of the section is that the information given by the accused must lead to the discovery of the fact which is direct outcome of such information. Secondly, only such portion of the information given as is distinctly connected with the said discovery is admissible against the accused. Thirdly, the discovery of the fact must relate to the commission of some offense. Embargo on the statement of the accused before the police will not apply if all the above conditions are fulfilled. If an accused charged with a theft of article or receives stolen articles within the meaning of section 411 IPC states to the police, I'll show you the articles at the place where I have kept them, and the articles are actually found there. There can be no doubt that the information given by him led to the discovery of the fact. Keeping of the articles by the accused at the place mentioned. The discovery of the fact deposed to in such a case is not the discovery of the articles, but the discovery of the fact that the articles were kept by the accused at a particular place. In principle, there is no difference between the above statement that made by the appellant in this case, which in effect is that I'll show you the person to whom I have given the time and exceeding search. Paragraph 14, Your Lordship. As held by this court, section 27 of the Evidence Act is an exception to the general rule under section 25 that confession made by accused to the police officer is not admissible in evidence. The first condition for applicability of section 27 is that the information given by the accused must lead to the discovery of the facts, which is the direct outcome of such information. Only such portion of the information given as is distinctly connected with the said discovery is admissible against the accused. Now, looking at the discovery memo so and so, it means that the accused showed this shock from which the medicines were so and so. These are the paragraph relevant to more particular this case. Now, Your Lordship is very much clear as regard to section 27 of the evidence, which is it's a general rule with an exception that the confession made before the police is to be taken as an evidence. Next, I'll rely upon the case extrajudicial confession. This is a case of 2020. I'm relying on paragraph 22, which Your Lordships will find at page number 14.
Yes, yes.
The confession statements made to the police by the appellants cannot be the basis to prove the guilt of the accused, but at the same time, there is no reason to discard the confession made to the independent witness at the time when Firaz's body was found, prior to the arrival of the police. It is true that extrajudicial confession is a big piece of evidence, but at the same time, if the same is corroborated by other evidence on record, such confession can be taken into consideration to prove the guilt of the accused. In the case on hand, the evidence from the independent witness is one voice and consistent. The medical evidence on record also substantiates the case of the prosecution. In addition to the same PWP, other parents of the deceased have identified the body which deceased was wearing so and so. It is clear from the evidence that the skeletal remained well removed. They have also confirmed. As it is clearly proved beyond any reasonable doubt that the appellants are responsible for the offense alleged against them. In this case, Your Lordship clearly states that even though it's a weak kind of evidence, but then it cannot be discarded just because the party is related in any way to the deceased. Now, if I may, so this is also an extrajudicial. Your Lordship, I'm relying on paragraph 14 and 15. Case of 2024, Your Lordship. Kalinga alias Tushar versus State of Karnataka by Police Inspector Hubli. Page number 5, Your Lordship will see paragraph starts from 14.
Yes.
The conviction of the appellant is largely based on the extrajudicial confession allegedly made by him before so and so. As far as extrajudicial confession is concerned, it is considered as a weak type of evidence and is generally used as corroborative link to lend credibility to the other evidence on record. In so and so, this court reiterated the evidentiary value of the extrajudicial confession in the following words. At this juncture, it may be noted that as per Section 30 of the Evidence Act, when more persons than one are being tried jointly for the same offense and a confession made by so and so affecting him and other of such is true, the court may take into consideration such confession as against other persons as well as against the person who makes such confession. However, this court has consistently held that an extrajudicial confession is a weak kind of evidence, and unless it inspires confidence or is fully corroborated by some other evidence of clinging nature, ordinarily conviction for the offense of the murder should not be made only on the evidence of the extrajudicial confession. As held in the state of MP through CBI versus Baldan Malla, the extrajudicial confession made by the co-accused should not be admitted. Paragraph 15, if I may, It is no more res integra that an extrajudicial confession must be accepted with great care and caution. If it is not supported by other evidence on record, it fails to inspire confidence. In such a case, it shall not be treated as a strong piece of evidence for the purpose of arriving at the conclusion of guilt. Furthermore, the extent of acceptability of an extrajudicial confession depends on the trustworthiness of the witness before whom it is given and the circumstances in which it was given. The prosecution must establish that the confession was indeed made by the accused, that it was voluntary in nature, and that the contents of the confession were true. The standard required for proving an extrajudicial confession to the satisfaction of the court is on higher side, and this essential ingredients must be established beyond any reasonable doubt. The standard becomes even higher when the entire case of the prosecution necessarily rests on the extrajudicial confession. Now, Your Lordship will see the entire witnesses who has made their statement, who were witnesses to such extrajudicial confession. None of the villagers forced him to confess. They said that they made an inquiry because he was seen last with the accused. And while the search was made, he was not present along with the villagers to go for a lookout for the missing person at that point of time. None of the villagers had forced him, and the confession made was voluntarily and in his presence of mind. Now, if I may take Your Lordships to the part of non-explanation made in 313. Lordships are well aware that under 313, it's when the prosecution witnesses are completed. That's where, when any allegation put towards the accused, those are the questions put by the magistrate to the accused, giving him a chance to make his explanation or give any reason whatsoever for such accusations made against him. This is also a 2023 case. Your Lordship will come to paragraph 41.
Yes.
Your Lordship will find that at page number 8.
Yes.
If I may read paragraph 41.
Yes.
Notably, no less than 627 question circumstances were put to A1 and A11 each under 313 of the Code of Criminal Procedure 1973. This court has clarified on numerous occasions that in law, the accused has a duty to furnish some explanation of an incriminating circumstances, with the prosecution crossing the threshold of proving its case beyond reasonable doubt. However, no explanation, much less a plausible one, is put forth. In the event of complete denial or silence, the court is entitled to draw an adverse inference against the accused. Lordship will see there has to, since those questions are for the beneficial of the accused, giving him a chance to refute all the allegations. The apex court has clearly stated on many occasions that there has to be some explanation, much less a plausible one, to be put forth to all the questions put to Lordship. However, in this case, Lordship will see In his 313, he had not made a single explanation as to where he about the bloods in the seized clothes, Your Lordship. No, not even a single explanation was made, and therefore my reliance on this that this court on not having done such explanation, made such an explanation before the court for any of the questions. The court has rightly taken an adverse interference against the accused, you know. Lastly, Your Lordship, with regard to the motive of the incident, Your Lordship. There is also a 2023 case of the apex court. I'm relying on paragraph 15, Your Lordship, which Your Lordship will find at page number 26.
Okay. Yes.
If I may read it. As regards the relevancy of the motive in a case based on circumstantial evidence, the way of authorities is on principle that if motive is proved, that would supply another link in the chain of circumstantial evidence. But absence of motive cannot be a ground to reject the prosecution's case. Though such an absence of motive is a factor that weigh in favor of the accused. In so and so, this court has referred to and relied upon the principle enunciated in a previous decision and has laid down as under. Now, so far as the submission on behalf of the accused that in present case the prosecution has failed to establish and prove the motive and therefore the accused deserve acquittal is concerned. It is true that the absence of proving the motive cannot be a ground to reject the prosecution's case. It is also true and as held by this court in so and so that if motive is proved, that would supply a link in the chain of the circumstantial evidence, but the absence thereof cannot be a ground to reject the prosecution's case. However, at the same time, as observed by this court in Babu, so and so, absence of motive in a case depending on circumstantial evidence is a factor that weigh in favor of the accused. In para 25 and 26, it is observed and held as under. In state of so and so, this court examined the importance of motive in case of circumstantial evidence and observed. The motive is a thing which is primarily known to the accused themselves, and it is not possible for the prosecution to explain what actually promoted or excited him to commit a particular crime. The motive may be considered as a circumstance which is relevant for accessing the evidence, but if the evidence is clear and unambiguous and the circumstances prove the guilt of the accused, the same is not weakened, even if the motive is not a very strong one. This court has also held that the absence of motive in a case, depending on circumstantial evidence, is a factor that weigh in favor of the accused. Keeping in aforesaid principle in view, when we examine the facts of this case, the concurrent finding of the trial court, so even in this case, Your Lordship, the apex court has clearly laid out that motive, if not proven, would also not discard the evidence, the rest of the evidence which corroborate with the other evidence.
Okay.
Now, I close in my summation. I would please like to humbly submit that this case is more particularly with regards to extrajudicial confession. Your Lordship has clearly seen that no pressure was made to the accused, and the accused, in fact, voluntarily confessed before the villagers. The accused has not given his explanation under 313 to rebut any of the allegations made against him, Your Lordship. And even the circumstances, the statement of the PW2, who is the prime witness, Your Lordship will see, the circumstances, the chain of circumstances has not been broken in any manner whatsoever, Your Lordship. Lordship will see from the time that he was with the accused and the time that they visited to the place of the deceased, Your Lordship. And the alcohol, the alcohol bottle found outside the room, Your Lordship will see. Yeah. And more particularly, the disclosure of the accused confessing to his motive of why he has committed such offense, Your Lordship, and subsequent recovery of the weapon as well as the report of the CFSL will clearly, and also the post-mortem report clearly establish a case against the accused, and the prosecution has rightly, the court has rightly convicted the accused, Your Lordship.
Okay. All right. Call it a day today.
I have a very limited role because the 310 CRPC now corresponding 338 BNSS, just to assisting the PP. So just supplementing, I find lordships are aware there are two fundamentals thing in a criminal case to convict the accused. So that is actors mens rea and the actors rea. And I find both this elements here in this case. And it can well be corroborated. Lordship will kindly, their lordship may kindly come to charge sheet page 8. One line is enough.
That's it.
Charge sheet page 8.
Okay.
This is the only documents I'm going to rely.
Yes.
In line 3, like line 3, Lordship. Then there is a full stop. These elusive fact was unearthed during the investigation of the instant case and a separate case. Why Dirang PS case number so and so 302 was registered recently and investigation launched. So that means if this man, his conviction is set aside and allowed to come out, he will again commit the crime. So therefore, I respectfully submitted that these men has both mens rea and actors rea. Guilty mind coupled with the actors rea, the physical actions. Well, we'll see this 161, 164, 313 depositions, and the evidence are impeachable, my lord. And then I find, my lord, this the 5 golden principles. My lord, kindly see, remember this. 1984, I'll not place this as judgment. The 5 golden principle, Panchil principle, you know. 1984, 4 SCC. 116, paragraph 153. This, because it is based on their circumstantial evidences.
Okay.
So in such kind of situations, this paragraph, I think all the 5 ingredients, their lordships, I find perfectly fitting
You're
into
quoting,
this case.
that
Judgment. Yes, yes. That Sarad
Sarad
1984. That much, I think, Professor, like, even when I was laying my hands, I could not find anything to, you know, anything my friend also as an amicus can defend. So I am also here as an amicus for the victim complainant. That much.
The victim.
For the victim
Complainant. Okay. Heart Learned Counsel, Mr. Ionil
M. Bozen.
M.
Bozen.
Bozen.
Yeah.
For the appellant, Learned Senior Advocate, Mr. T.T. Tarak. For the victim complainant and Learned Additional PP, Ms. T. Jini, no? Yes. For the state of Arunachal Pradesh. Reserve for judgment and order.
Yes. Amicus.
We won't be able to take in any more argument, I think.
Yes.
So.
My lord,
morning.
my brother's name can be recorded as amicus in this case.
Oh,
It is a jail appeal.
Yes, amicus.
Yes.
You just forgot. Amicus as amicus.
So, my lord, today no single bench will be there.
I will take up single matter, but argument I won't be able to absorb. Will I be able? Just tell me. Since morning we've been hearing and hearing. We have to exit and we have to intake and exit also. No, not a single order I have passed since morning. I'll come back for single bench.
Yes. This morning, my lord. The last time also I came, Justice Surana was here. My matter is at 4:30.
Is it very urgent today?
No, today is not possible. My item is 18 and 19. My lord, I had taken consent of my learned friend. Let it be fixed on 2nd December, my lord.
2nd December?
My lord.
I've seen you waiting since morning.
My lord.
18 and 19.
18 and 19. Second December.
Learned Senior Counsel Mr. S. Doctor is present. Learned Counsel Miss after a long time I've forgotten all your names. T. Wangmo is K. Wangmo is present. Government Advocate, no?
For respondent 1 to 5.
Learned Government Advocate GA Miss K. Wangmo is present. Correspondent number 5. Anybody else?
1 to 5.
Correspondent number 1 to 5. List this matter on
2nd December.
22nd December.
Much obliged. Interim may continue, my lord.
Interim order shall remain in force till the next date of listing.
Yes.
There's an interim order.
Yes, yes.
Okay.
Much obliged.
You want dates or shall the matters be left over? You're standing in such a long queue. Huh? Shall the matters be left over? You want dates? Everybody? Okay.
Today I have received an affidavit in opposition, Lordship. I want to reply the same.
Okay.
The matter may be fixed on 9 December, Lordship.
Number?
Item 20, I beg to mention item 20 for admission.
Learned Counsel Mr. A. Borwa,
No, PK Gogoi, Lordship.
PK Gogoi has submitted for time
Lordship.
to
I have received an affidavit in opposition. I want to reply the same.
time to submit his
Affidavit
affidavit
in.
in reply against the counter affidavit.
Yes, Lordship.
Please the
9 December, Lordship.
Learned Counsel, Learned Government Advocate Ms. K. Wangmo is present for respondents. List the matter on
9 December,
9
Lordship.
December. Okay.
Highly obliged, Lordship.
Everybody, you want dates, so should we leave it as leftover? Or you want dates?
Maybe, Sir Lordship, I'd like to unlisted matter regarding list this tomorrow morning, if possible. Yeah, tomorrow, if it convenient. Because in the last date,
Very possible.
in the Friday, I've already fixed the matter, but unfortunately not listed in the cause list. So single bench, WPC.
If possible, then maybe.
Please, demobilize.
My lord, I'd like to mention item number 30. May it be fixed on 5th of January.
5th of January.
5th of January.
Learned Counsel Mr.
M. Singha for the respondents.
Singha.
Yes,
On behalf of?
respondents, my
For
lord.
the respondents.
Yes,
30, item number 30
30. Pigo Riba.
is present. Mr. K. M. Singh.
M. Singha.
For the respondents. Anybody for the petitioner?
Yes.
Petitioner. Learned Counsel Mr. M. Kato is
For Union Vidya, madam.
for?
Ye-
M.
Which
Kato,
one?
you are present for?
Union Vidya, madam.
CGC?
Deputy Solicitor.
Union of
DSA.
DSGI, Learned DSGI, Mr. M. Kato is present. List the matter when do you want?
5th of January,
Madam.
2026.
Present for you, UOI, list the matter on 5th January. This, I think this has to be removed. Send someone to remove this. I cannot see her face.
Mobilized, my lord.
Somewhere here you can keep it, yes. I cannot see her.
Mobilized.
May I please your lordship? Lordship, I beg to mention for listing or petition. It was last listed on 5/9/2025, but I could not present here. Lordship, this matter may be fixed on 24th of November, Lordship, since there is in some urgency in this matter.
24th of November.
Yes, your lordship.
Can be possible?
Yes, Lordship.
All right.
Wonderful. Highly obliged.
Madam, may I mention item number 17? Madam, this is pertaining to suspension. The suspension, madam, without the reviewing the suspension within a period of 90 days, madam, they have the reviewed after more than 270 days, madam. So therefore, madam, this is a one urgent case, madam, as I have consented for tomorrow, madam.
Okay. Tomorrow?
Madam, subject to your lordship convenience.
Tomorrow will it be possible? Tomorrow, I don't know. Maybe day after tomorrow?
Madam,
Day after tomorrow, okay. 17 day after tomorrow.
Madam.
List on day after tomorrow. What is day after tomorrow? 15, 16?
day after tomorrow,
15, 19, 19. Okay.
19, madam. Wednesday, madam.
Okay. 19.
Biplab.
Lordship, I beg to mention,
Number 17 on 19.
Lordship, I beg to mention item number 15 and 16. Lordship,
Somebody has mentioned 15 and 16.
My lord, 17 is mine, my lord. In 15 and 16, I am for the respondent one.
15 and 16, not yet. There's a tick mark here. Nobody has mentioned.
no. I'm applying on behalf of conducting counsel for the petitioner PD Nair. Yeah. Conducting counsel
You for the respondent or the petitioner?
petitioner.
I'm for
Your
the
name?
respondent.
Your name?
Gitali.
Learned Counsel Mr. D. Tari on behalf of Learned Counsel Mr. PD Nair, with the consent of the other side.
Yes, Lordship.
Yes, sir.
Prayed for adjournment. List the matter when do you want?
Yeah, Lordship, after 3 weeks.
After 3 weeks.
Well,
Of Lordship.
Much of.
Your Lordship, I beg to mention item number 7 to 13.
7 to 13.
Yes, Lordship. In this matter, subsequent development is there, so I may be allowed to file IA.
9, 10, 11, 12, 13.
13, yes, Lordship.
Okay.
I may be allowed to file IA. So
Your for?
I am for petitioner side.
Learned Counsel Mr.
T. Tokur.
T. Tokur. With the
Yes, ma'am.
consent, have you taken consent?
Yes, yes, yes.
With the consent of the other side has prayed for adjournment. List the matter after
On 20th this month.
20th.
20.
Day after tomorrow.
Yes, Lordship.
On 20th.
Lordship, in connected matter, it's analogous matter is there. WPC number 415, 2024.
And
It's
with WPC number 41.
that may be club together. I may be able to file a IA in this matter. So to bring those records and subsequent developments there.
Full stop. It is submitted that the Learned Counsel for a petitioner will file an IA owing to some subsequent development.
Yes, yes, Lordship.
List on 20.
22.
Yes.
Lordship, I'd like to beg to mention the unlisted matter to be listed tomorrow in the motion stage.
Next tomorrow
And tomorrow, it's a very urgent matter.
can be. How many matters I haven't seen the list.
Yeah, has not been come out later on.
Okay.
It has been filed today, Your Lordship.
All
Most obliged.
May I please, Lordship? Lordship, I beg to mention one long pending writ petition 620 of 2024. It's related to service matter.
pending.
It was last listed on 9 September.
Speak.
Lordship, can it be listed day after tomorrow? Because similar matter has already been disposed of by this honorable court.
Day after tomorrow.
Yes, day after tomorrow, Lordship. If time permits,
Hope
yes,
it won't end up like today.
Lordship.
If it doesn't end up like today, then I can fix it for day after tomorrow, you see.
Lordship, yes.
Otherwise, again, you'll have to fall in line and then ask for dates.
Lordship may fix it day after tomorrow, and then as per your Lordship's convenient, and if time permits, then matter may be taken.
You're asking for listing
Yes, Lordship.
day after tomorrow.
Deeply obliged.
My lord, this item 3 and 4, it seems my lord is exhausted today. So I'm also exhausted, my lord. Can you pass over for tomorrow, my lord? Motion item. I have taken their consent, my lord.
Okay.
Item number?
3 and 4.
Tomorrow.
Tomorrow, my lord.
Hope it won't end like today. Again
It will not.
on 20th.
No, my lord, tomorrow.
Tomorrow.
Yes.
Okay.
28th, I will not be there.
Okay. Why not?
For some more.
3 and 4, no? 3
Yeah.
and 4.
Tomorrow. my lord.
3 and 4 tomorrow.
May I please? Finally, item number 22.
Mm.
This may be fixed on 27, Your Lordship.
On 27?
November, Your Lordship.
27 November. Okay. Item number 22 on 27 November.
Much obliged.
May I please, Lordship, I beg to mention item number 29.
Mm.
Today I am past time appears from the respondent number 5.
Mm.
We need to file affidavit.
Mm.
2 weeks time.
You have received respond today you have received?
Today I am past time appeal for the.
Oh, respond number 5. Okay.
Yes.
Item 21. 29.
29. Yeah.
What is your name?
Gita.
Learned Counsel Mr. G. Taye, appearing on behalf of the respondent number 5, has submitted for time as he has filed his wakalat number today.
Already filed.
Already filed. Oh, he's appearing for the respondent for the first time today.
Yes.
Okay. Anybody for the petitioner?
So I'm for the petition.
Here, my lord, I am for respondent 1 to 4, my lord, but my name is not reflected in cost,
Yes,
my lord.
yes. Not in the cause list.
My lord, may kindly direct the registry to reflect my name, my lord.
One more your name.
SA Agriculture, Standing Council Agriculture, my lord.
Letter, Standing Council, Mr.
L per me, my lord.
A.
L per me.
L. Parmi is present for respondent number
1 to 4, my lord.
1 to 5,
4, my lord.
4.
Hmm.
Whose registry to reflect the name of Learner Standing Council in the cause list. Anybody else?
Yes,
In
ma'am.
this
I'm for the petitioner, ma'am.
matter? Learned Council, Mr.
H lump, ma'am.
H. Lampu is present for the petitioner. List the matter
2 weeks, ma'am.
after 2 weeks.
2 weeks.
Obvious, ma'am.
Okay.
May I, Your Lordship? Lordship, I beg to mention item number 21. I'm stating on behalf of Standing Council, Tabatabu. Lordship, we need 3 weeks time to file a counter affidavit.
On behalf of
Tabatagum.
Council, Mr. T. Tagum.
Yes.
3 weeks time is sought, is prayed for to file affidavit.
Counter affidavit. Yes, Lordship.
List accordingly.
Your
You have
Lordship.
taken permission from the other.
Yes, Lordship.
With the consent of the other side.
Your Lordship, I would like to also mention item number 31 and 32 with the consent of other party. I beg to list this matter on 17th of December. 31 and 32.
Your name?
A Podo. I'm appearing on behalf of Y Dole. Respondent.
Learned Council, Mr. A. Podo, on behalf of Learned Council, Mr. or Miss?
Mr. Y Dole.
Mr. Y. Doloi.
Yes, Lord.
With the consent of this other side, has prayed for adjournment. List the matter on
17th of December.
17 December.
Obliged.
I beg to mention item number 23. I may be allowed 4 weeks time to file affidavit.
Learned Council, Mr. C. Modi.
O Modi.
O. Modi. With the consent of the other side.
Yes.
Has,
appearing for petitioner, Your Lordship.
okay. Has prayed for adjournment. File affidavit.
Yes.
Counter affidavit.
Yes, counter.
Your name?
Oh, Tirimi.
Petitioner.
Yes, for petitioner.
Learned Council, Ms. T. Rimi is present for the petitioner. List accordingly. 4 weeks time or
Interim,
list accordingly.
interim may be continue.
Interim order shall remain in force till the next date of listing.
4 weeks.
May I, Lordship, I'm appearing on behalf of M. Kamcham, counsel for the petitioner. Item number 2, I beg to mention item number 2.
Okay.
Yes. Matter may be listed on 20th of this month.
M.
Kamcham.
Kamcham.
It is not reflected in cost list, but
Okay.
it's there in
On behalf of Learned Council, Mr. M. Kamcham. List this, prayer is made to list this matter on
20th of this month.
20th of this month. Full stop, list accordingly.
Much better.
My lord, I may be allowed to mention item number 20. I am for the petitioner and I have taken consent from the opposite parties.
Somebody has, I think, mentioned.
Yes, adjourn. It has been mentioned by
Adjournment is
PK
already been taken
by PK Gogoi. 26.
26, item number 26.
26. Okay.
Yes.
Learned Council, Mr.
T. Omo.
T. Omo.
Yes.
With the consent of the other side.
Yes.
Has,
For the respondent number 7, Your Lordship.
okay, has prayed for adjournment. Learned Council, Miss.
And Anju?
And Anju is government advocate.
No, Your Lordship. Private respondent.
Is present for respondent number 7. 7.
Lordship.
Okay. When do you
List after 3 weeks, my lord.
list after 3 weeks?
My lord, interim or
Interim order shall remain in force till the next date of listing.
Obliged.
deeply.
May I, Your Lordship? Your Lordship, I beg to mention item number 24. I have filed Vakalatnama on behalf of respondent number 4 today. And Your Lordship, since the issue in this case is about legal aspects, Your Lordship. So therefore, my humble submission that this matter may be fixed for admission hearing after 3 weeks, Your Lordship. And meantime, if it is necessary, we'll file an affidavit
Pleadings are ready?
Yes, Your Lordship.
Sure.
Yes, Your Lordship. But we have not filed affidavit yet. But if it is necessary, we will file an affidavit.
If necessary, you'll file.
Yes, Your Lordship. Because the issue herein is about legal aspects, Your Lordship. So we'll be arguing on that mandatory of this case, Your Lordship.
Okay. Anybody is present for this side?
He is for the petition.
I'm for the petitioner, ma'am.
Learned Counsel, Mr.
Jay Bogo.
Your name is not there.
Yes, I'm
Appearing
appearing
for
over there. Yes,
Learned Counsel, Mr. Oak, your name?
Jay Bogo.
J. Bobo.
Bogo, B-O-G.
Who is present for Learned Counsel, Mr. Opada. He's for the government or something, no?
He's for the petitioner.
For the CBI,
SCB, SIC.
SIC,
Yes. Pelega.
CBI, Vigilance.
Oh, no, so this is a personal. Yes, yes.
Okay. He is present. Learned Counsel, Mr.
J. Sering.
J.
Sering.
Sering.
For-
Is representing respondent number
4.
4. And submitted that that pleadings are complete.
Yes, Your Lordship.
To stop. He has also further submitted that if necessary, they may file an affidavit.
Yes, Your Lordship. This matter may be fixed for admission hearing.
Meanwhile, they may file an affidavit.
Hmm.
Full stop. On submissions of both the sides, this matter is list this matter for admission.
Admission hearing, Your Lordship. After 3 weeks.
Admission after 3 weeks.
Highly obliged.
Your Lordship, I like to mention item number 14. I, on behalf of T. Torum, counsel for the petition, as per the previous order, so and so, today I have filed affidavit in the reply, so matter may be fixed for the admission hearing.
My lord, I'm for the respondent number 123, Rajiv Gandhi University, standing counsel. So matter of admission hearing may be fixed on 26th.
For admission.
For admission hearing, yeah.
For admission, 26 November.
Okay. Learned Counsel, Mr. Item number?
Item number 14.
Okay.
Your Lordship, I, on behalf of T. Torum,
It is submitted, Likidia. Learned Counsel, Mr. It is submitted on behalf of Learned Counsel, Mr. T. Torum, that you have filed affidavit in reply.
yes.
That affidavit in reply has been submitted. Full stop. Learned Counsel, Mr.
R. Nabam.
You are for government?
No, Rajiv Gandhi, standing counsel.
Huh?
Standing counsel, Rajiv Gandhi University. Respondent number 2 and 3. R. Nabam.
R. Nabam, comma, standing counsel for
Rajiv Gandhi University, RGU.
Rajiv Gandhi University.
Respondent number 2 and 3 only.
Represent full stop, comma, respond number 2 and 3. Anything else? Nothing. Okay. It is submitted by both the sides that pleadings are complete. List this matter for admission. Okay.
Fixed for
On 26?
26, Lordship.
26.
Lordship.
Okay.
Abhilaji.
Your Lordship,
Hmm.
item number 23, which was mentioned just before. Here, Your Lordship, I'm appearing on behalf of Mr. S. Datta. He comes from Guwahati. So here we are representing respondent number 125. Kindly, it may be recorded, Your Lordship.
Learned Counsel, Mr. Item number 23 to me is done here. Learned Counsel, Mr.
M. Kambo, representing on behalf of Mr. S. Datta. S. Datta.
M. Kabo.
M. Kambo.
M. Kambo.
Yes.
Present on behalf of Learned Senior Counsel. Mr.
S. Datta. Yes, yes.
Oh, okay.
Okay.
Representing respondents number?
125. Okay. 23. Okay. Obliged.
Item number 1.
My lord, this writ petition was against order passed by the state information commissioner by the order dated 31st July 2025. By this order, the chief secretary, learned chief secretary, was given a direction by the state commission to initiate a disciplinary proceeding against the incumbent PIO of the department. So subsequently, I had filed one application for recalling of that order. So during the pendency of this writ petition, I have filed that application, and this matter was last taken up on 2nd September. So this was the and the hearing of appeal was done on 4th of November this month in State Commission. So on that hearing date, the State Commission has recalled that own order, whereby direction was issued to the Learned Chief Secretary. So I think although there has been some initiation of sub process as per the direction of the State Commissioner, but since that order itself has been recalled, so I may be allowed to withdraw this writ petition with the liberty to approach this honorable court if they initiate any action as per that order.
If no action is taken.
No. Since order was already directed, issued to the Chief Secretary. Now, Learned Chief Secretary has.
Liberty, what type of liberty you want? You want to reflect some liberty in the order?
Yes.
What kind of liberty?
The liberty in the sense that if pursuant to that order, if any action initiated continues, then the petitioner has the liberty to approach this honorable court again. So that observation.
By the impugn order, my lord, the Information Commission has directed the Chief Secretary to initiate disciplinary proceeding against the petitioner, my lord. Once, my lord, the order has been recalled, my lord, suppose the Chief Secretary initiate a disciplinary proceeding, my lord, that proceeding can be challenged in another writ petition, my lord.
So that order has already been withdrawn.
Yes,
Information Commission's order
Yes,
to
madam.
initiate proceedings against the Chief Secretary has been withdrawn.
No, my lord, Chief Secretary was directed to initiate disciplinary proceeding
Yes.
against the, my lord, the writ petition, my lord.
Yes. So this direction was
Withdrawn, my lord.
Direction was withdrawn.
Yes.
Who has directed the Chief Secretary?
State Information Commissioner.
Okay, Information Commission.
Yes, ma'am.
Yes.
Against the PIO.
Yes, PIO.
Okay, Learned Counsel, Mr.
T Omo Tapi Omo.
T.
T Omo. Yes,
is
yes.
present. And for the
For respondent number 2, my lord, R. Sekia, my lord.
you are present for the petitioner, writ petitioner.
Yes,
He
writ
is
petition.
present for the petitioner and learned government advocate,
No, my lord, I am extending counsel, my lord, Information Commission, my lord.
learned standing council, Information Commission. Your name?
R. Sekia, my lord.
Mr. R. Sokia is present for learned council. Mr. R. Sokia is present, learned council, no, standing council. Is present for Information Commission.
Yes, madam.
And you are present for
Respondent number 1, Your Lordship.
learned council means
P. Pangu, Your Lordship.
P.
Pangu.
Pangu is present for government advocate.
Yes, Your Lordship.
Government advocate, council is for respondent number 1. Full stop. A proceeding was directed to be initiated against the petitioner by the Information Commission.
Yes.
Full stop. Aggrieved by the direction, the petitioner was before this court. Full stop. Now, however, the direction has been withdrawn.
The order passed by order dated 31st July 2025, whereby the direction was issued, has been recalled.
Now the order dated 31st July 2025 has, however, the order dated so and so has been recalled
Recalled by the commission.
by the commission. Full stop. The petitioner thus seeks to withdraw the petition with the liberty to approach this court again if any further proceeding may be initiated against the petitioner.
As per the order, last order.
No, my lord. If the learned Chief Secretary initiate any disciplinary proceeding against the petitioner, he has always the liberty to challenge that, my lord, proceeding. Is because the first root of the order has been recalled, my lord.
Difficulty here is, my lord, because.
May observe that with liberty, my lord.
Yes.
Yes.
Yeah.
The last sentence I will just delete it. Last sentence to delete Korea. Thereby the petitioner is allowed to withdraw the petition with a liberty to file a fresh petition. If any, whatever liberty just
Instead of fresh, my lord, appropriate petition, my lord.
with an appropriate petition.
That will do.
That is better.
Yes. Obliged.
Item
Item number 5.
May I please, Your Lordship?
Yes, yes.
Lordship, many were, by impugn order, many were terminated and their appointment order was cancelled. Page number 23, by which the many the employees were terminated and the page number, and they approached this honorable court in WPC number 368, 638,
So this is WA.
No, my lord. By the, that in that judgment, the order, that has been disposed of with the directions to the departments to consider their case after verification, the petitioner is seeking similar order,
Okay.
The annexure, the page number 47, annexure 6, which I have annexed,
So we'll issue notice.
No, this can be disposed of with the consent. Yes, similar direction,
Let's see which order.
Annexure 6, page number 49, and similar order is, the operative portion is page number 85, This is the left out, the petitioner. Altogether, earlier, the 188 petitioners in numbers. They approached this honorable court in WPC number 638, page number 49, and that has been disposed of on
WPC number 638. page
638, correct, and by order dated 7 November, the entire petition has been disposed of with
Page
that.
49, 711.
Correct.
Order dated 711.
Yes, madam.
Okay.
Page 85, madam. So, the petitioner is seeking similar direction.
Similar direction, okay. Learned Council, Mr. Standing Council. DSGI.
No, my lord. Here I am for the private respondent, private petitioner. madam.
Petitioners, okay. Learned Council, Mr. M. Kato is present for all the petitioners.
My lord, also sole respondent.
Only one petitioner.
One petitioner.
For the petitioners, Srimati Sumi Taing. First of Learned Council, Mr.
A. Podo.
A. Podum.
Podo.
Podo is present for
Tabatagum, respondent.
Standing counsel for the respondent.
Standing Council
For the education department.
for Education Department, Mr. A. Podo is present.
Yes, Lord.
For respondent number 2.
My lord, all respondents. 1 to 5, madam.
1 also.
Yes, madam.
Okay, okay, yes. 1 to 5. So where is the main crux? Which paragraph? That order? You have come against which order? Which
Well-
paragraph?
Termination order, my lord, page number 23, my lord.
The petitioner is before this court against the termination order dated
16 November 2023, madam.
16 November 2023,
Yes, ma'am.
passed by the
Learned Commissioner, Education Department,
Learned Commissioner Education Department,
respondent number 1, madam.
comma, respondent number 1,
Correct.
represented by respondent number 1.
Yes, ma'am.
In this case, it will be represented.
No, my lord, the commissioner himself has passed an impugn order, madam.
Okay. The respondent, he's not respondent number 1, Commissioner here.
Commissioner is the respondent number 1, madam.
Respondent number 1 in this case.
Yes, madam. Page number, my lord, 2. Sorry, 4. State of Arunachal Pradesh represented by the Commissioner
Okay,
Education.
respondent number 1. Full stop. It is submitted on behalf of both the sides that now what is the position?
My lord, only
They have been
direction.
reinstated.
No, my lord. Only for my lord, direction to be given to the respondent number 1
Okay.
for consideration of the case of the petitioner, along with the lordship has seen the order
Okay.
7/11/2025, madam. Annexure 6, madam. My lord, may I simply pass the order with the
It is
directions?
submitted that we'll copy the order.
Yes, madam.
Huh?
Since this has been disposed of in similar way.
Page number 85 of copy kori diba sab jihin correction ko bare mo kori dim. If something is required, then I may recall also the order. I'll check.
Yes, madam. Also, my lord, simply given a direction in similar order, my lord, this can
I'll
be-
just give a direction, okay.
Yes, madam.
It is submitted by the Learned Council for the petitioner that he has a limited prayer and the direction may be given to the department.
Correct.
To the department to what? Cancel the termination order.
Yes, madam. No, my lord. And my lord,
I'll go to the prayer portion.
yes, my lord. It is in my lord, last portion, my lord, page number 87, my lord. 87 and 88, my lord.
No, your prayer portion.
My prayer portion is, my lord, the similar direction, my lord. It is in page number 18, my lord.
Page number
18, my lord.
18, okay. Limited prayer and a direction may be given to the department to set aside
Yes, my lord.
and quash the impugned termination order, white number likhiba, huh? Capital ED hyphen 12015 stroke 5 stroke 2023 dated 16/11/2023 dated nalage dubar issued by the respondent number 2.
Correct.
This is
One, my lord. Respondent number 1.
On 23/11/2023
Yes, my lord.
within bracket annexure 1 bracket close. Full stop. Considering the submission of both the sides, the respondent number 1 is hereby directed to
Consider the case of the my lord, the petitioner in similar way is passed in my lord, the order dated 7/11, my lord.
so this was the prayer for quashing, no?
Yes, my lord. Quashing, my lord, but this honorable court has not interfered with the impute termination order, simply given the directions to the my lord, respondent department to verify and consider the case.
Quashing to nalage direction likhi diba. Quashing likha asal nahi. Nalage hetu nalage.
My lord, we are seeking my lord, similar direction
Yes,
is my lord,
yes.
or passed by
Yes.
this honorable court in other writ petition.
Itu enake likhi diba. Without going into the merits of this case, comma, the matter can be remanded back to the respondent authorities for verification and reconsideration of the case of the petitioners.
Correct, my lord.
As it is stated to have been done in the case of some similarly situated persons.
Correct, ma'am.
Full stop. The petitioner was working as
PRT, my lord. Primary teacher, my lord.
PRT
Yes, ma'am. Under
under
the
the Directorate of Elementary Education, comma, Department of Education, Government of Arunachal Pradesh.
my lord.
Full stop. Hetu je EED enko je lisla. It is contended that by order dated etia likhi diba. EED etia likhi diba. 1 2 ekhini issued by the respondent number.
1.
But here you have stated 2 in your petition prayer.
I'm sorry, my lord. I have not seen. Basically, my lord, if lordship perused the annexure 1, the impugned order was issued by the commissioner, my lord. Respondent number 1, my lord.
Okay. I'll just mention his commissioner's name.
Yes, my lord.
A respondent number 1 nilikibla by the commissioner within bracket education, Government of Arunachal Pradesh. Full stop. Hey, order to likhi diba ha EED etu. Next prayer likha. It is submitted that while another impugned order similarly situated petitioners also were terminated from service.
Yes, madam.
And this court in,
WPC.
you want me to mention this case?
Yes, madam.
WPC number?
Yes, madam. We are seeking same and similar direction, madam. That is required to be mentioned, madam.
WPC number 638 of 2023 has directed
Page number, my
The
lord.
respondent number 1,
Yes.
being the commissioner and secretary, education department, to take up for consideration the case of the similarly situated writ petitioners of WPC number 638 of 2023 and conduct the necessary verification regarding the nature of the appointments and based on the outcome of such a process, pass necessary speaking orders, as per law, and also considering the aspect of parity with similarly situated persons. All right.
Madam, madam.
I have considered the submissions at the bar, full stop. Considering the limited prayer, the respondent number 1, all right?
Yes.
Commissioner, secretary, or the entire respondents?
My lord, only Commissioner Secretary, my lord.
Ah.
Commissioner, my lord, Education.
Or we can mention entire respondents?
My lord, impugn order has been passed by the
Okay,
Commissioner. my lord.
the respondent number 1,
Yes, ma'am.
to take up for consideration the case of the present petitioner and conduct the necessary verification regarding the nature of his appointment, his or
Her, my lord.
her appointment, and based on the outcome of such a process, pass necessary speaking order,
Yes, ma'am.
as per law, and also considering the aspect of parity with similarly situated
Correct, ma'am.
persons.
Person.
In terms of the above order, this matter stands disposed of.
My lord.
Or anything else?
No, my lord, that will
Conditions,
cover.
anything else?
My lord,
If
that
they
will-
don't take up, nothing.
my lord, that will be the another cause of action since if they don't file, my lord, the fast impugn speaking order, my lord. Much of it.
Obliged.
Item number 6.
My lord, this is second round of writ petition, my lord. What happened earlier round of writ petition, my lord, we are basically against the, my lord, the impugn, my lord, the LPCs issued in favor of private respondents, my lord, here in Malan. During the, my lord, the pendency of the past round of writ petitions, my lord, the deputy commissioner, my lord, revoked the, my lord, the, cancelled the, my lord, the impugn LPCs 18 numbers, my lord, issued in favor of the private respondent. After that, my lord, again, my lord, my lord, the cancellation order, the private respondent approached this honorable court again, my lord, by being aggrieved of the, my lord, the cancellation order, my lord. During the, my lord, the writ petitions filed by them in private respondent, filed by the private respondent, my lord. What happened, my lord, again, deputy commissioner has, my lord, revoked the order, my lord. After revoke, my lord, the meaning thereby, my lord, the impugn LPC issued in favor of this private respondent is stand, my lord. So therefore, my lord, we are again, this is in this second round of writ petition, my lord, we are, my lord, seeking for the cancellation of the order, my lord, the LPC issued in favor of the private respondents, my lord. So at this stage, my lord, the notice may be,
The other side also will issue notice.
my lord, and at this stage, my lord, the notice may be
You will issue
issued.
notice.
Yes, my lord.
Lordship, in the meantime, that after passing the order of the DC, Your Lordship, the private respondent in this writ petition, they have withdrawn the case.
Withdrawn is after, my lord, the revocation of the order, my lord.
Yes,
They
after.
concealing is the, my lord, the revocation order, they withdrawn, my lord. And in that case, my lord, we filed the, my lord, IA also, my lord, for impleadment, my lord. During the pendency of our IA, as well as their writ petitions, my lord, they withdrawn, my lord. Only because of that reason, my lord, the impugn, my lord, the
LPC.
cancellation order has been revoked by the deputy commissioner, my
In
lord.
IA petition, when they file IA petition, during that time, Your Lordship, they have withdrawn the case, withdrawn the writ petition, the private respondents in this writ petition, present writ petition. So after withdrawing, Your Lordship, in the meantime, what they have done, they have filed IA again. Recently, in the month of November, and they want to alter, modify the withdrawn order, Your Lordship. They want liberty to file afresh, Your Lordship. So the Honorable Court on the last occasion in IA, they have directed me to get the instruction from the Deputy Commissioner. So it's pending and it will come after 2 weeks, Your Lordship. So my prayer will be to list this matter along with that IA, Lordship.
Yes, my lord. Not in the meantime, notice may be issued, my lord. And
Not notice, Your Lordship.
Let's list it together.
Together, Your Lordship.
no, my
Then
lord,
we will issue notice.
Yes, we'll get
my
the
lord, our
instruction from the DC also.
our contention is something different, my lord.
No,
Here, my lord, the contention is maybe I have not seen the, my lord, IA they have filed, my lord. But my contention is this impugn order, my lord, the impugn LPCs has been issued in, my lord, contrary,
Yes.
my lord.
LPC or
LPC, land possession certificate, my lord.
Yeah.
In without consulting the, my lord, the authorities, without consulting us, who are ultimately the user of that forest, my lord, that has been given to the, my lord, the forest land, my lord. It is a, my lord, the reserve forest area, my lord. That cannot be given away to the, my lord, the private individual, my lord. This is a community land. Moreover, we have the rights to, my lord, the use the forest products, my lord. We can, my lord, even my lord, the extract the forest products.
You are from the petitioners from one community.
Yes, my lord.
All right.
Oh, same villagers, my lord. But my lord, by deceiving us, my lord, they surreptitiously, my lord, obtain the impugn LPCs 18 numbers in their favor, my lord. Thereafter, my lord, what happened against that? We moved this honorable code, my lord, by filing, my lord, I've enclosed the, my lord, other read petition also, my lord. That has been, my lord, closed only because that, my lord, the deputy commissioner has cancelled the impugn LPC or LPCs issued in favor of them, my lord. My lord, thereafter, against that cancellation order, the private respondent approached this honorable court, my lord, challenging the, my lord, the recall, my lord, the cancellation order, my lord.
Yes.
And during the pendency of cancellation order, my lord, the writ petition filed by them, my lord, we, my lord, approached this honorable court for impleadment. Now, my lord, the pendency of the, my lord, the writ petitions filed by them and our IA for impleadment, they, my lord, subsequently withdrawn on the grounds that, my lord, that cancellation order has been revoked by the deputy commissioner, my lord. Now, meaning thereby, my lord, once it is revoked, the cancellation order has been revoked.
Understand?
Yes, ma'am.
That order against you.
Yes, ma'am.
Lordship, that
So therefore,
revocation
my lord-
order was a temporary order during the pendency of the writ petition. Your Lordship may kindly see page 171. It is a temporary order till the final disposal of the writ petition. But now when the private respondent has withdrawn the writ petition, earlier writ petition, so this order of cancellation of LPC, it goes, Lordship. This revocation order, Your Lordship. And the cancellation of LPC, it retains again.
Yes.
Technically, Your
Exactly.
Lordship. So he has no grievances actually because LPC, cancellation of LPC is there.
No.
So now IA has been filed by the private respondent, Your Lordship.
No, it is wrong.
Because writ petition has been withdrawn. So, and this revocation order was passed during the pendency of the writ petition and pursuance of the order passed by the High Court, Your Lordship.
No, that is wrong, man.
Interim order. How can it will be a permanent?
During that, in the case of that writ petition, earlier writ petition, this revocation order was passed.
It won't be temporary.
Yes.
It was,
It will be a
Your Lordship may
permanent-
kindly see the order, Your Lordship, 171, Your Lordship.
One
171 page, Annexure 28.
Annexure 28.
Yes.
Yes.
Last paragraph, Your Lordship. May I read the whole order, Your Lordship?
Okay, till disposal of the writ.
Till the disposal. Now the writ petition.
Let us bring it together.
Yes, Your Lordship. That will,
Disposal of the writ petition.
it was till the
Revoke
disposal.
disposal of the-
And writ petition has been
This writ-
withdrawn.
My lord, this writ
Withdrawn, Your
petition
Lordship.
is of the my writ petition, my lord.
No. It is a writ petition of the private respondent.
And they have withdrawn it.
Yes, that is,
Let us bring both the.
yes,
together.
that will be,
Be prejudiced.
yes.
Let
Well,
us bring,
well, then-
will issue notice.
Yes, my lord.
Yes.
Then in
It will
that
come
case,
after, the matter was,
then after, my lord.
the matter was listed on 7th of this month. And after 2 weeks, it is going to,
Along with, we will.
yes,
Yes.
along with
Ma'am.
A number 269.
In fact, we are not aware of that IA, my lord. That is the another reason, my lord. That has not been, my lord, even intimated to us, my lord. Whereas,
When this will be taken up, then.
Yes, it will,
You'll be already there.
yes,
yes, my lord. My lord, our IA, lordship,
It will be taken up together.
yes.
my lord, in that case, my lord, may I take your lordships to the page number 172? Again, my lord. I'm sorry, my lord.
I understood.
Yes, my lord.
But this is only till withdrawal of the petition.
Yes, and we have been asked to get the instruction from the deputy commissioner, the status of the case.
Till withdrawal.
Yes.
You won't be prejudiced. This is temporary. I
No.
know it's against you, but this is temporary.
No, my lord.
Okay, I will issue notice.
Yes, my lord. That will be better, my lord. That's because this will be definitely
And Kato Land Council, you're for private response.
private response.
Yes.
Private petitioner, my lord.
For the petitioner,
For-
petitioner.
Let the matter come up together, Your Lordship.
Yes, madam.
Then the
Notice
things
may be-
will be clear, Your Lordship. If I get the instruction from the DC, Your Lordship.
Notice, my lord, notice may be issued. Yes,
The private respondents,
yes, my lord.
come to the DC. You are for the DC now.
My lord,
Yes, yes,
definitely, after issuance of notice, my lord, this will be listed together.
Number 6
Correct, ma'am.
Item number 6.
is present for the petitioners or petitioner.
Petitioners,
Petitioner.
16 numbers. ma'am.
Miss
Arbasar.
Al
Arbasar.
Prasad is present, the learned government advocate is present. For respondent number, how many?
126, Lordship.
Issue notice to the other respondents,
My lord.
returnable on.
2 weeks, after 2 weeks. ma'am.
Returnable after 2 weeks. We list this matter along.
Along with IA number 269 of 2025.
My lord. Deep level.
Obliged, Lordship.
Item number 25.
Time is over. Do you want to submit item number 25? 25 and 27?
No, actually,
We'll fix a date.
yes, actually, they are supposed to file reply.
Reply.
Yes.
Have you filed a reply? Have you filed your reply?
Item number 25.
25 years.
25.
You are supposed to file reply.
No, I'm for the petitioner.
Who will file reply? Petitioner?
Your Lordship,
Counter affidavit, who will file?
we have filed our affidavit opposition, but
So you will
they
have,
have not filed.
if you
No.
file, if you don't want to file, then we'll fix it for hearing.
No, Your Honor, the chairman, departmental promotion committee, they are supposed to file.
Okay. Who is that? Respondent number?
Respondent number 3,
3. Okay, learned counsel, Mr.
El Soki. El Soki.
L. Soki is present for the petitioner,
Yes, ma'am.
comma, learned counsel, Mr.
Your Lordship, see the appearing on behalf of Deepangi.
C. Dajo is present on behalf of learned
Deepangi.
private respondents.
Yes, Your Lordship.
Learned counsel, senior counsel, no?
Yes,
Mr.
no.
D. Pangi,
Yes.
he's senior, no?
No, Your Lordship.
Mr. D. Pangi, representing the respondent number,
Your Lordship, private respondent.
representing the private respondents, learned government advocate, Miss G. Wangmo, K. Wangmo is present for respondent number
1 and 3 month.
1 and 3.
Yes.
Full stop. Do you have to file anything?
My Lordship.
According to him, you have to file a reply or affidavit.
The last,
There's extra copies also now.
Okay, please serve them extra copies.
okay, we'll provide.
Full stop. Extra copies of the petition to be served on the served on the respondent number 1 to 3. List after 1 week, 2 week.
1 and 3, actually, 2 they have filed
1 and
their
3.
reply. Yes.
List after 1 week, 2 weeks.
3 weeks.
3 weeks.
Highly obliged. ma'am.
Item number 27 and 28.
27, I think somebody has submitted something, 27, 28.
Yes, I have filed an IA application.
Okay.
For the implement of the applicant in the WPC number 228, 2025, Lordship.
We'll hear it, or you have any objection, or should we?
No, my lord, here in the item number 27, I am respondent number 1. And in 28, I am the petitioner. So I have an objection. I want to file an objection in regard to this implement of this.
So here,
So
in you are for, in WPC number 228, you are for
petitioner,
petitioner.
yes.
Okay, learned counsel, Miss here.
D. Riba,
D. Riba is present for whom?
applicant. I am praying for implement of the applicant as respondent in the WPC.
Okay. WPC 228.
Yes.
You are present for Nabam Nanu.
No, I am for Techi Talita.
Is present for Teche Tamita.
Talita.
Teche Talika, and has submitted a petition for implement of Teche Tamita.
Talita.
As respondent number? As respondent in the?
In the WPC to
In
228.
this present WPC is in this present writ petition. Full stop. Learned Counsel, Mr.
N. Taje.
N. Taje is present for Nabanganu.
No, I'm for the petitioner. In here in the item number 27, in the IA, I am the respondent number 1.
Is present for,
Yeah, one kar diya.
who is respondent number 1?
TM Enterprises.
Is present for TM Enterprises.
Yes, madam.
And 4 others, no.
4 others.
Is present for TM Enterprises. Duita join koi likhi diba. Duita gutekta ekalage likhi.
And Your Lordship, I am for respondent number 4 and 5, Your Lordship.
Learned,
4, Your Lordship.
Learned Government Advocate
ma'am.
Miss N. Pasa.
P. Pangu, Your Lordship.
P. Pangu
Yes,
is
ma'am.
present for for the
Re-
state of Arunachal Pradesh.
Yes.
I'll mention it like this because I'm clubbing all the petitions together.
Okay, Your Lordship.
Full stop. The Learned Counsel for Mr. For Enterprise, TM Enterprise
TM Enterprises.
has submitted for time to file objection.
Yes, 3 weeks
In-
time.
3 weeks time to file objection in which case?
In IA.
IA.
Yeah,
In IA number 274.
Yes.
274 of 2025. So, what a club ko likhi diba. List accordingly. All right.
Otherwise, Your Lordship.
Much obliged.
Anything else? No.
No.
Nice to come to Arunachal Pradesh after a long time.
Why?
And then I can